Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first is 24 CV 739 Gene R. Brooks et al. Versus Mitsubishi Electric and Electronics USA Inc. et al. Counsel, when you're ready, if you want to come to the podium and let us know how much time you'd like for rebuttal after you introduce yourself.
Good morning, and may it please the court, Yusenka Marjanovic on behalf of plaintiffs appellants, and I'd like to reserve 3 minutes for rebuttal, please. As part of this appeal, this court must decide 2 central issues de novo. Whether the Brooks plaintiffs can properly be bound by the trial court's substantive rulings under Daubert in the Murray case, and whether the Brooks plaintiffs can also be bound by the case management orders in Murray. The answer to both of those questions, we respectfully submit, is no. And that comes from a straightforward application of binding Supreme Court precedent as well as precedent from this court. Under the circumstances of this case, moreover, it would be fundamentally unfair to bind the Brooks plaintiffs to these orders. And that is an issue that this court must decide under an abuse of discretion standard only if it first finds that the fundamental requirements for the application of collateral estoppel have been satisfied, and here they have not been.
Counsel, so, I mean, there's a lot in your intro, and let me see if I can try and sort of get us to where I think the nub of the issue is. You mentioned collateral estoppel. Let's assume collateral estoppel just does not apply here, right? We're talking about whether or not you're bound by an interlocutory order, not a final order that, allegedly your clients agreed to before it was made. That sounds like nothing like collateral estoppel, right? So I think it's really, we are under Taylor versus Sturgis, was there an agreement express or implied? Can we start from there?
Your Honor, regardless of whether we apply the label of collateral estoppel or not, I think the issues are the same.
Maybe the factual and procedural issues are the same, but I think it matters that this is not, right? There's a whole test for collateral estoppel. I think no one is arguing that this satisfies that test. I don't think the trial court thought it satisfies the test. I think the real central concern is whether or not there was an agreement. And I think that's where I'd like to focus attention on sort of what happened below and who said what when to indicate that there was or there wasn't an express or implied agreement. Can we start from there? Is that okay? Or is there some reason that you think we really need to look at this? I mean, like I said, I don't see collateral estoppel being relevant or applicable here.
Let me address your question in 2 parts, and I'm happy to focus my argument on the question of whether there was an agreement to be bound. But I believe that there is an additional issue that even if there was an agreement to be bound, the court must also consider whether it would be fair and there was a fair opportunity.
I hear you on that, although I tend to think that whether or not we found an implicit agreement would incorporate some of these issues of fairness. So it doesn't seem quite like a separate question to me, but let's maybe put that aside for the second and just talk about whether or not there was an agreement. And do you want to tell me why? I guess also I'm a little confused, but I'll just put this out there. It's not so much a question, it's an observation that you can talk about when you're telling me why there was no agreement. The separation of whether or not you're bound by the substance versus the case management. It seems like if you're bound by the substance, it's all of a piece. That, if I understand correctly, the defendants are saying everybody took a gamble on what the court was going to say about the admissibility of expert testimony in this case. The defendants didn't want to defend against, this issue multiple times, and the plaintiffs didn't want to have to prove it multiple times. So everybody said, we're going to go forward with the Murray cases, and that decision to go forward with the Murray cases encompassed the case management issues. It seems very odd to me to say, oh, we agreed to the bottom line result, but we didn't agree to the case management aspect of it. So that is something that I'm not understanding, but we can talk about that as we talk about why you think there was no agreement here.
Sure, let me address that, but I'll do it as part and parcel of why there was no agreement. So under Taylor versus Sturgill, as well as the restatement, it's black letter law that a party who agrees to be bound is bound by the terms of their agreement. And the Supreme Court interprets that
I mean, right, that's express, if there's an express agreement, sure. If there's an applied agreement, then you kind of have to figure out what the terms were, and there's going to be some play in the joints there, right? So, yeah.
Here, Your Honor, we have an express agreement, and under this court's precedents and contract law, when you have an express agreement, that's what governs. You can't then imply some broader agreement than what the plain terms of the contract provide.
So that's an interesting position for you to take. Okay, so your position, I take it, is that the stipulations that your clients entered into between 2013 and 2014, is that right?
Yeah,
Thereabouts, right? That those are the operative agreements.
yes, Your Honor. And
But
those,
what is so odd to me, if that's your position, that that's the universe of the agreement, that there was an express agreement at that time, right? So this is coming after Judge Burgess has issued the original case management order in response to your request to start off with the Fry-Dias ruling, right? Your request to, well, I mean, it's in your words, and I can find the transcript. So to,
Your Honor,
there's
that's the Murray plaintiffs.
I get it, but the agreement, the stipulation has to be read in context, right? We're not going to just take it out of context. And there's an agreement because the stipulation references the Murray plaintiffs. So the Murray plaintiffs have said, we want to go first with the Fry-Dias ruling. And the stipulation says, we want to be bound by that ruling, right? What's so interesting is if your position is that the express agreement is the stipulations, once this court says Daubert applies, one would think that your stipulations are moot, right? That there's nothing there anymore. And that is not how the parties or the court behave. If you go to the remand hearing in 2016, after we've said Daubert applies, the court says, this is when you're saying, okay, now Daubert applies, we want general causation discovery. And the court says, I'm not going to give you that. But the court at that point says, but why shouldn't we peel off the non-consolidated plaintiffs, the non-Murray plaintiffs, and let them do their thing, and we'll bifurcate it that way.
Let me address.
Counsel for the plaintiffs, who are wearing multiple hats at this point, say no. I mean, they don't say no expressly, but they indicate in so many words, that is not what we want. And in the interest of efficiency, I believe they use the word efficiency, we want to keep going the same way that we're going, which would indicate that their express agreement to be bound by Fry-Dias is now an implicit agreement to be bound by Daubert in the Murray hearings. And why is that wrong?
I actually think the record of that remand hearing is actually central to this case, because Judge Weisberg expressly found during that hearing that the agreement to be bound was based in part on the Fry-Dias test applying. That was his finding on the record. And when they addressed how the remand proceedings would move forward and whether plaintiffs could name additional experts or revise their opinions, he expressly found that it would be unfair to the plaintiff.
He doesn't make a finding. He asks, and he asks counsel for their position. And neither counsel says, you're right, that would be unfair. Don't do that. Decouple the non-consolidated plaintiffs. Neither counsel does. And then he asks at that hearing, he says, I want briefing. You tell me what you want. We're here to talk about how discovery should go in this new Daubert landscape. Tell me what you want. Tell me what this is, how this is going to work, and in his order denying the motion for additional discovery, he says he makes a mistake and he attributes the unfairness argument to plaintiff's counsel. Plaintiff's counsel didn't make the unfairness argument. He raised the unfairness concern. And he says, this was raised at the hearing. It hasn't been briefed. And so I'm not talking about it. Effectively, he's saying, I think this issue has been abandoned.
I don't read it that way. May I point you to a few pieces on the record
Absolutely.
of that hearing? So this is at appendix 4972 going to 73. He says, to be bound by the Murray order, it does seem to me that you'd have to be able to go beyond what you did in Murray to be fair to those plaintiffs. And then at 4977, he again.
But I just want to point you, after he says that, counsel for the plaintiff says, look, we don't want all the discovery that the defendants are saying that we want. We want targeted discovery. Counsel for the plaintiffs doesn't pick up this unfairness banner. Right? And he says, look, this is what we want to do. We just want to keep this as on 4975. We want to keep, if not all the experts that we have, then most of them. Will supplement these reports. And this way, we're not prejudicing all of our other clients. And we're going to be more inclined to allow this to be binding on everybody that's in this project here in DC. So that's all I'm asking is this court. Otherwise, you've got to do what you've said. You've got to take these 38 cases and put them on another track. And there's really just no judicial economy served by that.
Your Honor.
That's what counsel says. In other words, he doesn't want that to happen. He's not asking for it. He's saying, don't do that.
Your Honor, there were two tracks that were being proposed and discussed. If it went the way that the defendants wanted, which is no additional discovery, no new experts, no opinions from 2013, then we do not want to be bound by that because that is unfair. If you go,
I get that. That's an interesting argument, except that that's not what was made to the court because the court says, I raised this concern and nobody briefed it.
Your Honor,
that's in the order. And so had counsel said, look, you give us all the discovery we want. We're cool with sticking with the Murray plaintiffs. You don't give us all the discovery we want. We want to be decoupled. There's no way. That's not what counsel said. It's not what it was. It's not what was briefed unless you can show me in the briefing that that's what was requested. But I didn't see that in the record. I'd be more than happy to look at it. But footnote 1 of the order says no one briefed this.
Your Honor, that was in 2016. But what the court did rule on the record there was that
the court didn't rule anything on the record. The court said, I want briefing. This was the hearing post remand, December 12th, 2016. And the court issued its order on the issue of additional discovery on March 16th, 2017. So it took the court 3 months to issue an order. Sometimes that happens. And it was directly responsive to this hearing. And if you want to point me to a filing that where plaintiff's counsel picks up the banner and says, absolutely, if you can't give us the discovery we want to be decoupled, I'd be very interested to see that, but I didn't see that argument at the hearing.
Your Honor, at that time, there was no briefing because there was a question of to what extent the Murray plaintiffs would be allowed to raise new opinions. And Judge Weisberg ruled that they could take into account the 2013 science that happened after that and amend their opinions to address Daubert. Judge Josie Herring then interpreted that opinion later to bar the plaintiffs from doing so, thereby raising the unfairness that Judge Weisberg had forecasted. And the plaintiffs, once it became clear, there was a bunch of litigation back and forth for years about how much discovery.
I thought we were just talking about this hearing because you said this hearing was critical.
It
And
is-
so I just want to make sure that we finish talking about this hearing, because at the end of the hearing, Judge Weisberg says, I think we should continue to stay these cases, the non-consolidated cases, long enough to resolve the 13 Murray cases. I think that makes sense. And defense counsel says, yes, I mean, plaintiff's counsel says, yeah, I understand.
And the restatement is very clear that you cannot impute an agreement to be bound from a decision to be stayed. And Judge Weisberg decided that there was still benefit to continuing
It's not
stay.
implying the decision to be bound by the decision to stay. It's just that had counsel not wanted to be bound, it seems like counsel would have said a lot of very different things, both at this proceeding, after the proceeding, before the court filed its order denying the motion for additional discovery. And then in response to subsequent communications from the court and orders from the court, right? I mean, you mentioned Josie Herring, the Chief Judge Josie Herring's order. Again, there's no argument in real time in response to that to say we want to decouple.
The possibility that that might be a ruling from a subsequent judge down the line. I mean, at that hearing, Judge Weisberg said, I'm coming off this case. This is, I think that was, he said, this is my last hearing. So the possibility that Chief Judge, or I think at the time, just Judge Josie Herring would rule in the way she did was certainly knowable or predictable, right? So you would think that at that point it would have been raised, even though it hadn't happened yet.
Well, Your Honor, that would require someone to believe that what was ordered by one judge would be changed by another, which is uncommon. There was an agreement and an understanding that they would be able to amend their reports. And if they had been allowed to fully flesh out the science and fully present the issue of general causation, we might be at a different point, because the question of what's fair and what they agreed to turns on whether they were able to present the full science. And the fairness turns on that because the Brooks plaintiffs were filed later in time. They shouldn't be bound by what was initially the opinions of the science as it existed in 2013. So for them, it's not foreseeable that a later judge would say that that's not allowed. Now, I want to be very clear about what the agreement
When
was.
did Chief Judge Herring, Josie Herring, issue her order?
Let me look, Your Honor. And I will flag for the court that in 2021, the plaintiffs did again raise the issue of whether the cases should continue to be stayed. But I really want to stress that in 2016, what was the agreement that the parties made? And with doubts having to be resolved against issue preclusion or against preclusion and being bound, they agreed to a continued stay. And there's efficiencies to a continued stay, whether they're bound or not.
Expressly agreed to a continued stay, but they implicitly, what I'm trying to grapple with is whether they implicitly agreed to continue to be bound by the Murray litigation about the admissibility of expert testimony. And I just don't see where they said, right, they could have walked into that hearing and said, you know, those stipulations that we filed in 2013 and 2014 that said that we agreed to be bound by the admissibility of expert testimony under Frye-Dias? We don't agree to that. It's Daubert now. We don't agree to those now. We want to litigate the admissibility of our experts in every single one of these non-consolidated cases.
What they argued.
But they didn't say that.
What they did argue and what the two tracks were that were discussed at the 2016 hearing were either the Murray plaintiffs are allowed to supplement their reports with new science, in which case the plaintiffs would agree to be bound, or if they were not, as Judge Weisberg said, it would not be fair and they would not agree to be bound.
Weisberg didn't say it wouldn't be fair. He expressed concern and asked counsel for their position on it, and no counsel bit.
No.
Not plaintiff's counsel, not defense counsel. No one wanted a world in which they were litigating the admissibility of expert testimony under the Daubert standard in some 38 additional cases individually.
At the time of,
And they could have said, well, look, we don't want to do it individually. We want now to consolidate a new group of cases where we have a new, case management order and a new, way of, a new discovery order. And, Murray is passed. Fine, we agreed to that before, but we're not agreeing to that, to this new set of cases. And it's just, it's resounding what they didn't, it's the dog that didn't bark. It's not in there.
let me address, like, if I can point you to a few more pieces of the record from 2016 from Judge Weisberg. What he ultimately found at that hearing is inconsistent with the conclusion that there was an implicit agreement to be bound by the plaintiffs. He said, I don't think that I should order that the other 38 cases, the more that you're going to be filing while all this got would not be bound by that. But I think I should continue to stay those cases at least long enough to resolve the 13 Murray cases. That was the outcome coming out of the 2016.
What appendix page are you reading from?
I am reading 4983. That was what was coming out of that hearing was, listen, we need to decide how much discovery is going to happen in Murray. I am not holding that they're going to be bound at this time. I am going to say that this is an issue that needs to be decided later on. And we know that because we can also see it in his order of
I don't disagree. He doesn't decide you will be bound, but that's not the issue. The issue is whether or not whether the Brooks plaintiffs implicitly agreed to be bound. And my point is, they don't make any argument at this proceeding where the court is the one raising the concern. They don't make any argument that they shouldn't be bound. And it's almost a gift from the court that it's saying, well, I'm not going to decide this now. Because, I only, noticed this proceeding for the Murray plaintiffs, even though I recognize that they're all you guys are the Brooks plaintiffs and the non-consolidative plaintiffs lawyers. So he doesn't say I'm going to decide it, but the question is what your clients implicitly agreed to.
But if they implicitly had agreed to it, it would not have been a live issue anymore. If they had said, yes, we're going to be bound, one, you would have to find that.
It just means that no one has finally decided that they implicitly agreed. The court didn't get derailed on that, just said, okay, I'm keeping focused on the Murray issues and, we'll figure this out later. But when later comes along, and it comes along a lot later, years later, because this issue was not pressed by plaintiffs, at that point, the judge on the case says, yeah, I think there was an agreement here.
Well, let's look at the 2017 order of the judge who is there and who's hearing these arguments. He rules, and this is at Appendix 1745, Note 1, but you've raised this note, was that the Murray case's agreement to be bound is based in part on the understanding that Dias-Freitas would determine the outcome. He says at the hearing, he understood, and he was there, this is the record before the court, that plaintiffs did argue that it was unfair to hold them to the agreement now that the outcome will be determined by a new standard. And the defendants disagreed. And the court says, I'm not addressing that issue now. So as of 2017, it is a live issue of whether there is any agreement, continuing agreement to be bound. And that is the ruling of the court, the judge who understood and heard these arguments. Now, in 2021, for the next couple of years, there is a back and forth about how much would the Murray plaintiffs be able to amend their reports, take into account new science. That is a live issue. That is the central issue of whether there is an agreement, because as Judge Weisberg found, if they're allowed to totally amend, it may be fair to bind them and they would agree. If they can't amend, if they can't fully take into account new science, they're not going to agree and they're not going to be bound. And that issue goes back and forth for years. And then in 2021,
you say it goes back and forth, but you actually, you don't prevail at any point in that back and forth, right? There's no point at which it seems like it's going to go your way. It just seems very odd that if the Brooks plaintiffs really didn't think that they were bound and didn't want to be bound by the Murray litigation, that they didn't at some point say, we're going to cut our losses. These cases, as has been highlighted in the briefing, we don't have schedule, like we don't have answers with these cases are brand new cases. Let's just start afresh. We can consolidate a bunch of these new cases and not be burdened by any scheduling orders, case management orders, discovery orders, and we can just structure this case in light of Daubert the way we want to without the baggage of the Murray cases. And that just never happens.
Your Honor, the Murray plaintiffs did prevail in front of Judge Weisberg. Judge Weisberg did rule that they were allowed to take into account new studies in science and amend their expert reports to address the new standard. And this court in the Murray appeal held that that was a reasonable reading of Judge Weisberg's order. It held that reasonable minds could view it as allowing the amendment and the introduction of new opinions. Now, that was the status quo. And then Judge Josie Hearing disagreed with that. Then there was motions for reconsideration regarding that.
Can you remind me again the date of that ruling?
Let me find it for your honor. So the order denying the motion for reconsideration was July 2019. The last strike order was November 2018. There was a motion to add a new expert witness in April 2021, and in August 2021, when it was clear that there would be
at
no.
that point, right? I mean, if Judge Josie Herring's ruling is sort of the nail in the coffin, right? And you think it's clear now that you're not going to get what you want. I'm not sure why we're looking at 2021. There's just this gap in time.
Your Honor, there's continued litigation, motions for reconsideration, motions to add new experts. There's continued issues. And in the meantime, there is a stay from Judge Weisberg, and agreeing to a stay under black letter law, under restatement law, is not the same as agreeing to be bound. Now, I want to address the second part.
I just wanted to pinpoint that stay from Judge Weisberg, that's the operative stay. Is that I got confused reading the record, like which stay are we talking about, right? Because there's a stay at the
Yes,
beginning.
Your Honor.
That stay expires once the Fry-Dias hearing is held, arguably.
And
Then there's a stay pending appeal. That stay expires presumably when it comes back. And then there's Judge Weisberg's stay at the post remand hearing, and that's the operative stay throughout the remainder of the litigation of the Murray cases?
yes, Your Honor, that would be the last and operative stay.
Okay.
And at that time, you have to take Judge Weisberg's words for what they mean. There wasn't an agreement to be bound, and there was an open issue about whether there would be an agreement to be bound. And after years of litigation, when ultimately it was very clear the motion for reconsideration was denied, the motion to add a new witness was denied, the plaintiffs moved to lift the stay. And they made the arguments that they had never agreed to be bound. Now, I want to be very clear, because in the record, there's some confusion about why would you have a stay if you're not agreeing to be bound? And there's lots of reasons. That happens every day in cases across the country. There is benefit, there's efficiency benefit, even if you don't agree to be bound. Let's say the court had considered the full opinions and said these are inadmissible. And those were the same experts that they were going to use, plus Judge Portier or somebody else. Well, now that whole part, you're not going to relitigate that. The same judges are not going to say, oh, in one case it's admissible, in the next one it's not. It makes it efficient and cuts off a large portion. And that's why there was a continued stay. When they moved to lift the stay, and if we look at that, again, if we look at Judge Irving's order, that's August 31st, 2021. And the premise is that there was some implicit stay or that there was a clear implicit stay. And I want to be very clear about the law there as well. The restatement
Implicit
states,
stay or a clear implicit agreement?
so I want to be very clear. The restatement states that if you're going to infer an agreement, it must be on the plainest of circumstances. And the Supreme Court's decision, which I do want to discuss, the Zenith versus Hazelton opinion, is very instructive here. There has to be a plain, clear, implicit agreement. And no one until the very end of this case holds that that's the case, because Judge Irving, looking at it in 2021, says that the language of the stay orders is not uniform, and the weight the determination in the Murray cases may hold in subsequently filed cases is not necessarily clear at this
back. I guess I found that totally confusing because he's looking back at the original stay, and I thought that's not the stay that's in place, right?
He's looking to see what is the weight that the Murray cases are going to get. And he says that's not clear. And then he still finds, regardless if there's an agreement to be bound, there is justification for a stay. There's still an efficiency to having a stay. And so I'm going to continue the stay without finding that there's an agreement to be bound. And now I do want to address the Zenith versus Hazeltine.
Are you trying to say that there is never a point when anyone finds that there was an agreement to be bound?
The implicit agreement to be bound was first found after the Murray-Daubert decisions, when that was addressed at summary judgment. That is when the court, for the first time, finds that there was an implicit agreement to be found.
And what's wrong with that? What's wrong with having that perspective and looking back and saying, looking at everything that's happened and all the water that's gone under the bridge, I think the way that this is played out is that you implicitly agreed to be bound.
Your Honor, when we look back,
Are you saying there's a timing issue, or are you just saying, actually, it's not the timing, it's not that the court didn't do this until summary judgment, it's just that the record that it looked at didn't show an implicit agreement to be bound?
the record that it looked at did not show an implicit agreement to be bound. And judges across time, up until that last order, agreed. It wasn't clear.
No, they didn't
There wasn't
agree.
a-
They just said, we're not going to decide. That's what I want to make sure I understand, right? Like, you're
Judge-
saying there's no problem with a judge at the end of the proceeding saying, I think there's an implicit, like everybody else has kicked the can down the road. We're not going to decide if there was an implicit agreement to be bound. We'll let somebody deal with that later. And it's just not litigated until a lot later. And once it's litigated, it's decided at the summary judgment stage, and you don't have a problem with that. What you have a problem with is the substance of the decision, that there actually wasn't a record of on its plainest terms, or whatever the language is from the restatement, that there was an implicit agreement to be bound.
I don't have a problem. Well, I have.
I mean,
a
do you
problem.
agree
I
that
have a problem.
they
with
kicked the
timing.
can down the road?
I don't, Your Honor, because if we look at the words of the judges that had this case across time, they are consistently finding that it's not clear. There's not a clear agreement
Well,
to
in
be bound.
2016,
Let's-
Judge Weisberg says, I'm not deciding that.
But he says it's not necessarily clear, and I'm not going to dive into it. And then Judge Irving.
But somebody could dive into it more and figure it out, right? I mean,
Right.
when a judge says I'm not deciding it, it's usually pretty clear that they're not deciding it.
But they're also stating that it's not clear. And Judge Irving said the same thing, it's not clear. And there is an issue with timing, because this court is faulting the plaintiffs for not objecting earlier. But earlier, there was not a court finding that there was any agreement to be bound. The express agreements to be bound only related to Degas and Fries. And then there was a question of, would there be an agreement to also be bound by Daubert? And that, based on Judge Weisberg, that hearing before Judge Weisberg, turned on the extent to which the Murray plaintiffs would be allowed to raise new science, fully flesh out the opinions, and address it. And because that ultimately they were prohibited from doing it, there was no implicit agreement. There was two tracks these cases could have gone on. And the one chosen by the court was to bar the Murray plaintiffs from fully accounting for the science that had developed since 2013.
Which
And-
ruling determined that the Murray plaintiffs would not be able to file supplemental reports and flesh out the records?
There was multiple rulings over time that were litigated. The ultimate ruling denying the leave to add a new expert was April 21st, 2021.
But that was denying a new expert, not denying the ability to cite new reports.
That expert was taking into account new science since
But the
2013.
old experts were allowed to cite new science in their reports.
And the final ruling addressing that was in July 2019, but that also, there was a motion for reconsideration for that. It was still an unresolved issue. There was a motion for reconsideration of that at the later Dauber hearing, which happened in, gosh, you guys are really testing my memory here, in September 2022. So this was still
In
in
this
the,
case, these cases were, they started to be filed in 2001. And I get that the Brooks plaintiffs didn't file until 2013 and 2014. But if there is, if there's science to support expert testimony linking cell phones to cancer, then it seems like at some point, right, this can't go on ad infinitum, which is what we said in the Murray decision last year. So at some point, the defendants are entitled to go to trial too. And so I'm not understanding sort of what the boundary of your argument is as far as new science is concerned. They were allowed to put in new science. They were allowed to put in new science between, it sounds like 2013, and you said the cutoff was 2019. So that's 6 years of new science. What's the limit? Like how,
Sure, Your Honor, and it's a balancing test, but I do want to say they were not allowed to fully account for science through the filing of the revised expert reports, because Judge Josie Hearing said you can only do it if it precisely matches up to a very specific opinion. Like, it was not just any new science. So if there was a new study that didn't precisely match up to something you had said, she struck it. And she struck it sometimes based on like, you didn't use this specific word. And so now that's not allowed. So they were not allowed to fully account for the science. I think the Ninth Circuit's case in Pomona is instructive here, right? And this court's precedents flesh this out. You do want to balance the delay and judicial sides with the judicial and societal preference, a strong preference for deciding cases on the merits. And the question of whether you can amend to add new science has specific factors that this court has considered, including whether it's the fault of the plaintiffs that this wasn't previously done. This is a unique circumstance. This isn't a case where over time they're continually amending the reports. This is a case where there was a decision finding their experts admissible and then a long stay for an appellate process not initiated by the plaintiffs through no fault of their own while the science evolved. Now, the question is prejudice. Is there prejudice of adding this new science? Does it delay the schedule? In this case, in the Murray cases, they couldn't have delayed the schedule because the Dauber hearing wasn't held until 2022. You could have had enough time to depose, to do all the work without having to strike the new science. The same schedule that the court had set, regardless of whether new science was going to be kept, stayed in place and could have stayed in place with the new science. So when you're considering a motion to amend or a motion to add or supplement, there is a balancing test. The court requires totality of the circumstances.
it sounds like you're trying to relitigate the Murray rulings, which we reviewed in the Murray case last year and upheld.
Under an abuse of discretion standard. In this case, the inquiry is slightly different. It's not what was decided in Murray, not just whether it was correct, but whether there was a full and fair opportunity to litigate the issues. And that's an issue that is decided de novo by this court. And that's critical because I think in Murray, the standard of review played a large role. This court found that it was reasonable to view Judge Weisberg's order as permitting the supplementation of new science, including new opinions, but it declined to second guess the judgment of the trial court because it was doing an abuse of discretion review. In this case, you're not deciding just did they get it right or wrong, but taking the totality of the circumstances, all the different orders that came down, do we have a full and fair opportunity to litigate the issue such that binding the Brooks plaintiffs, the non-parties, is fair and meets the requirements for binding someone? That issue is now decided de novo. And it's not just decided de novo, but, and defendants took issue with this, but the restatement is very clear. The Zenith versus Hazeltine case indicates that doubt should be resolved against preclusion. And there are many, many cases across the country, including in the District of Columbia, that have held the doubts, if you have any doubt that there was an implicit agreement, it has to be resolved against preclusion because it is a fundamental notion of our justice system that you get a full and fair opportunity to litigate your case in court, especially when, and I think the court agrees, it seems to agree with me, that there is no express agreement to be bound that could be interpreted to allow the binding of the plaintiffs in the way that was done here. You have to do an implicit agreement. And the standard for that is extremely high and for good reasons, because we're talking about due process rights and your right to a day in court. That's a traditional notion that's foundational in this country. So
I think we have your argument. If you want
just
to
ask
wrap up or
one
answer
question?
Judge
Yep.
Thompson's question first.
Sorry. A few moments ago, you were starting to point us to an order where the court first found an implicit agreement to be bound. What order was that?
So, Your Honor, the order would be the summary judgment order that is ultimately on appeal here. Let me point you to the record. Give me just one moment. That would be starting at Appendix 2894. And I do want to be very clear that the implicit agreement to be found there was largely based on the language of DeRosa, which was only applicable to one case.
But our review is de novo, so we are looking at the whole record, right?
Yes, Your Honor.
I feel like you have in your head a timeline of sort of key events, and I wish I had that timeline. Do you have that timeline in your head, or do you have it somewhere that you could make it available to us?
I would be happy to file a supplemental, if that would be helpful, just a short timeline of what I think the key events are, or I could walk through it here if.
I wouldn't have you do that, and maybe we'll discuss whether we think it would be helpful, but it seems helpful to me. I'll just say that.
Sure. Would you like me to walk through kind of the timeline?
I wouldn't take your time now, but I have a feeling that you have that timeline in your head. I wish I had it in mine.
And I'm happy to file just a short and happy to give the defendants an opportunity to respond.
Thank you, counsel.
Yeah.
We'll give you a few minutes in rebuttal.
Thank you, Your Honors. Terry D. on behalf of the defendants' appellees in this case. I first want to address one point that the plaintiffs' counsel brought up at the end about a full and fair hearing. This court already addressed this issue in the Murray 2025 hearing and expressly found that the court below gave appellants, quote, a full and fair opportunity to present their case. That issue has been resolved. It's already been resolved. And while it may have been an issue on appeal, that was before this court issued its Murray order and found there was a full and fair opportunity below.
It says that we were only reviewing for abuse of discretion below in the Murray case. What's your response to that?
Well, there is no review of that decision in this case because that's part of the collateral estoppel analysis, and there is no collateral. We agree with the comment you made at the outset, Judge Easterly, that collateral estoppel is completely irrelevant to this case. It wasn't briefed by the parties below. It wasn't analyzed and resolved by the court below, and that wasn't the basis for the court's decision. So the analysis of whether the parties had a fair and a fair opportunity to litigate below in the Murray case is not before this court. It's part of the agreement analysis.
It's not whether they had a fair opportunity, it's whether or not they agreed to be bound. And we're trying to figure out, was there an agreement, express or implied? Happy to hear your argument as to whether or not you think there was an express agreement. It seems more that we're in the world of an implied agreement. And the backdrop of what happened in the Murray cases, the plaintiffs have argued is relevant to whether or not there was an implied agreement because they weren't, I can't tell if they're arguing, well, we were agreeing to go along with it until it didn't go our way, or we hadn't agreed to anything and we were, the express agreement from 20 agreements from 2013 and 2014 were just defunct. And so we were just kind of in this limbo where there was no agreement. And why would we have agreed? I'll stop there.
So look, our position is there was an express agreement, but lacking an express agreement, there was also an implied agreement.
Well, talk to me about why you think there's an express agreement.
Yeah, sure. So
the express agreement, I take it as the stipulations that all of the Brooks plaintiffs filed.
Well, it's the totality of the circumstances provides the express agreement, and certainly the
Yes, I've been
stipulations are
thinking
part of
that an express agreement needed to be actually in writing or at least like verbally announced on the record, like, we agree X, Y, and Z. And the only thing that we have of that nature are these 2013, 2014 stipulations, whereas, Murray is being litigated and, therefore the parties agree that this case should be stayed in its entirety until after the court's resolution of the Frye-Dias hearing in the Murray cases, and that the court's ruling in the Frye-Dias hearing in the Murray cases will apply to this case. That's an express agreement. It seems to take you to the Frye-Dias ruling. I don't know what happens after this court says, actually, Frye-Dias is not the law anymore. And are you arguing that it is still expressly binding because you should substitute in terms and say, well, actually, they agree to be bound by the ruling in the expert admissibility hearing, not the Frye-Dias hearing?
So let me start with at the outset, you're dealing with Taylor and the restatement and the idea that both express and implied are based on the totality of the circumstances. So we look at what is in the record. Yes, there are the stipulations, and the stipulations included a proposed order. And the proposed order is what the court entered in each of those cases. And as Judge Irving points out, all of the stipulations and proposed orders and the orders are substantively identical. And they say not only, they make the point that there is this threshold issue of general causation, and that there is, and the proposed orders incorporate the parties' statements at the 2012 hearing, which were on the records. Those also reflect the agreement. So you have the parties' statements that, the threshold issue is general causation. It incorporates the 2012 hearing transcript, and that the parties in the totality of the circumstances were dealing with general causation as the threshold issue. Frye-Dias was just proxy for it's just a standard. It's not what was driving the efficiency in these cases. It was the standard that applied to the threshold issue of general causation. That's what was.
And by general causation, we mean the admissibility of expert testimony about whether or not, right? Because there's a whole debate about what general causation means before Judge Burgess.
Yes.
That predates these stipulations, where Judge Burgess says, I didn't mean cause and effect. What I meant was, can you meet the Frye standard for your experts?
Well, I think what this court ruled in the 2020, most recently when this issue came up in the Murray cases is in fact that what Judge Burgess was focused on was general causation, not Frye-Dias. In fact, the court said nothing in Judge Burgess's decision to structure discovery in phases depended on any nuance of the Frye-Dias standard. Instead, Judge Burgess grounded his decision in the sound logic that general causation would prove dispositive if resolved against appellants.
Yes, we said that. And Judge Burgess said what he said. I guess I'm just want to make sure that we're all on the same page about what general causation means, because I find it sort of a confusing term. By general causation, do you mean the admissibility of expert testimony about whether or not cell phones can cause cancer? Or do you mean general causation, like do the defendants have evidence of cause and effect?
So general causation means is the RF that comes out of phones capable of causing the injuries, the brain tumors and cancer that the plaintiffs have alleged? Are they capable of doing that? Phase one discovery, in this case, focused on general causation, was focused on whether the plaintiffs could submit admissible expert testimony on the issue of general causation.
Okay, so
Because
general causation is the shorthand for whether or not there's admissible expert testimony about cause and effect.
yes, and so at the time, Frye-Dias was a standard. So Frye-Dias there was no indication that the court was going to change the standard from Frye-Dias to Daubert. So of course, when the court refers to the hearing, it's talking about a Frye-Dias hearing. So
It's talking about the plaintiff's designated experts, correct? I mean, that's what everybody was talking about.
talking about them submitting experts reports and submitting those experts to a hearing to see whether they could satisfy the Frye-Dias standard
Right.
on general.
General
causation.
discovery had been stayed, correct?
That's right.
And I mean, the example that I kept thinking of is this. I wonder whether you would think the plaintiffs were agreeing that if, for example, they heard a rumor that the defendants had in their files some paperwork saying that cell phones cause cancer, acknowledging that. I'm just making this up, obviously. The plaintiffs would still want discovery on causation to get to those documents, even if their designated experts all fell under the Frye-Dias test, correct? That's why I don't see that the argument was about general causation, or that's why I'm not persuaded we can read the stipulation as being a stipulation about not looking further into general causation. It was a stipulation about staying things in other cases while the admissibility of the testimony of the Murray plaintiff's experts got litigated. That's how I read it. Why is that wrong?
Well, there's certainly a distinction between the admissibility of the plaintiff's experts on general causation. Can they satisfy the standard to get admissible evidence in on general causation? And then separately, the sufficiency of the evidence to prove general causation. If you look at Judge Weisberg's order from 2014, where he initially gave his Frye-Dias ruling, he actually made that distinction saying, hey, we're going to take this phase one and bifurcate it again into the ruling I'm making right now, which is on admissibility. And then secondly, now we're going to go into discovery on just general causation to determine sufficiency. So his view of phase one, that it was a general causation phase with admissibility of the experts' testimony on general causation being the first part of that phase.
But was there agreement by the plaintiffs that failure to satisfy that first subpart of phase one would basically end the litigation for them? I know there's
Yes.
comments in the various transcripts that if they're unable to establish general causation or expert admissibility on general causation, that would effectively end the litigation. But was that part of the express or implicit agreement?
It was all part of the express agreement or implicit agreement. However you want to look at this, But that's what's so important about the stipulations, the proposed orders, and the orders themselves that were entered in each of these cases, because they did incorporate the 2012 hearing and plaintiffs' specific statements about what the agreement was. They said that phase one was their, quote, one shot for general causation, because if they didn't present experts with admissible general causation testimony, quote, we're done. And then we don't go back. And then they also agreed to be bound by the phase one discovery determination in the Murray cases.
I mean, it's probably not before us at this point, or it's almost definitely not before us at this point, but doesn't that seem like a strange thing to agree to if, as Judge Thompson's hypothetical had played out, even if they couldn't get admissible expert testimony on general causation, that if the defendants had this hypothetical document, this smoking gun document, that they were willing to say that that wouldn't be enough, that they would be out at the first step?
No, because if you're talking about general causation in totality, so again, phase one was two parts. It was, is there admissible testimony? One. And two, is there sufficient evidence of general causation? Two. They would have been entitled to that, get that hypothetical document as the second part, the sufficiency part of phase one. So that's why they agreed to it.
And when would they have been? I mean, I'm just looking back at the 2012 hearing. This is before the stipulations are entered in the Brooks, what become the Brooks cases, right?
Looking at the stipulations, Your Honor, or the?
No, I'm looking at the hearing,
Okay.
right? The hearing before Judge Burgess, right? That Judge Burgess issues the initial case management schedule on November, he has a hearing on November 15th, 2011, and subsequently issues this order. I don't have a date on it. Oh, sorry, on December 7th, 2011. And then there's some confusion about what the case management order means. And in September of 2012, they have a hearing and defendants are saying, sorry, I keep saying defendants when I mean plaintiffs. Plaintiffs are saying what the group of plaintiffs who become the Murray plaintiffs are saying, look, we only need one Fry hearing. It would apply to all cases. When we get to the status conference, these other cases that have been filed subsequently, the parties have agreed to be bound by the phase one discovery in the cases that are currently pending, as well as the Fry hearing, without upsetting the schedule, without adding anything, because the issues are the same in terms of general causation across the board. It says, no, when I said general causation, I just meant, general causation generally means the question of whether a substance is capable or causing or causes a particular disease. But what I'm talking about is whether or not, what I was talking about is whether or not you could get expert testimony in. And I'm not giving you this general causation discovery separate and apart from whatever discovery you need for your Fry hearing. So I thought that that was clear pretty early on, that that's how the case was going to proceed.
That was so that's the
You just
two-part.
said, no, they would have been able to get the smoking gun document because they were entitled to general causation discovery. I thought Judge Burgess said the opposite.
So that's the distinction between the two parts of phase one. So the phase one first part is the admissibility of the plaintiff's experts on general causation. Part two is the sufficiency of the general causation evidence. Whatever other general causation evidence
Okay,
that
I mean,
supports.
I'm still not following because I think Judge Thompson and Judge Schenker have expressed concern about what if there had been a smoking gun document and if they agreed to limit discovery just to Fry Dias issues, they wouldn't have access to that smoking gun document, but you said, no, they would. So I'm not,
No,
maybe I'm
so-
misunderstanding.
Yeah,
I'm
I think
just
there's
not
a,
following
there,
along.
there, and look, we litigated this in front of Judge Burgess, we litigated it in front of Judge Weisberg, and these issues came up. We need to get all these documents that are internal to the plaintiff's internal or the defendant's internal files. And what the court below determined and what this court affirmed is that none of that information is relevant for the admissibility determination. That what the parties, what scientists rely on are the scientific studies, not the internal documents within the company's files. And so there's a lot of litigation, a lot of briefing that came up on appeal in Murray on this very issue of whether discovery focused on admissibility that did not include the company's internal files was fair. And this court, the courts below, all uniformly said
Right,
yes,
but here
and this
we-
court did
And
too.
we're trying to figure out whether the non-consolidated plaintiffs agreed, right? They agreed, yes, let's see what the Fry Dias litigation produces and we'll be bound by that. But did they agree that they were giving up general causation discovery from the get-go?
Yes, and that's clear from their statements in the 2012 hearing. This is at Appendix 000430, where the plaintiff's lawyer speaking about this very issue and talking about the efficiency that would be inherent in having the Brooks cases bound to Murray said, the Brooks parties, quote, have agreed to be bound by the phase one discovery in the cases that are currently pending, as well as the Fry hearing, without upsetting the schedule, without adding anything, because the issues are the same in terms of general causation across the board. And so they have that
But it's
admission.
subsequent to that I thought that the court said, look, I think when you say general causation, that's not what I mean. And that there's this delta between the use of general causation. Look, I mean, it may well be that there was the delta and then this proceeding resolved it and then they entered the stipulations anyway. But the question is, what did those stipulations then mean?
The stipulations meant exactly what they said, which is that the parties agreed to be bound by the admissibility determination in the Murray cases. And as part of that, they incorporated the admissions on the record from the September 12th hearing. That, and then in looking at the totality of the circumstances, as your honor's question plaintiff's lawyers, the conduct, that's also was critical to Judge Irving's determination. The conduct of the parties and the courts after that was consistent with that understanding. It came up that, whether the orders were defunct after the stay orders were defunct in the Murray cases after the decision by Judge Weisberg in 2014. And that's not what happened. If you look at, for example, the DeRosa order that Judge Weisberg entered, he ordered that the court's rulings on the admissibility of expert witness testimony on general causation in the Murray cases following remand of the District of Columbia Court of Appeals will apply to this will apply to this case as it will apply to all related cases pursuant to prior orders of this court. So he didn't make this order continued and applied to the determinations on general causation, the admissibility.
What's the date of the DeRosa order?
It's January 7th, 2015. It's
I mean, it's
Appendix
weird
173.
because in the Kaspersky order, he says that the stay is moot, the request to stay the case, right? The cases are coming in at different times. And I guess there's a new plaintiff's case by Mr. Kaspersky, and he's asking for a stay, but at this point, the Frye-Dias ruling has already come down. And the court says, well, that request is moot because I've already ruled. So I'm not going to stay this pending.
Yeah, there was a stay in Kaspersky though. I don't have that in front of me because it actually all
Well, the
gets
stay
wrapped up.
comes up, I think, after, because the court then certifies the cases for appeal, and then the court says, well, now I'm staying everything. This is why I was asking plaintiff's counsel, which stay are we looking at, right? And I think the operative stay, the stay that's initially entered in 2014 in all of the Brooks cases, those do expire and are superseded, right? Either by the certification order that issues a stay or subsequently by the stay that Judge Weisberg orders in 2016 or 2017 when it after the case is remanded.
So a lot's going on, but I think that what these orders say is that, and I know the plaintiff's counsel took the position that DeRosa doesn't apply to the other cases. We're not taking the position that the other plaintiffs were bound by DeRosa, but what DeRosa says is that this order will apply to this case as it will, or it should say that the admissibility of general causation determined on remand after the Court of Appeals has ruled on the issue of the standard will apply to this case as it will apply to all related cases, meaning it's interpreting all the orders as the same. There's no daylight between the Brooks order and the DeRosa order in terms of how the court interprets the
And so
parties' agreement.
your point is that if plaintiffs had a problem with that, they should have said something.
Absolutely. And then of
But
course,
what about the point that subsequently courts looking at this issue more squarely say, we're not actually going to decide whether or not the plaintiffs are bound by the Murray discovery rulings, but that we'll deal with that later.
I'm not familiar with any court saying that. Judge,
Maybe I'm misspeaking,
Judge Joseph
mischaracterizing, but for example, in the March 17th order after the first remand hearing where the court says, look, we talked about possibly decoupling the non-consolidated cases from the Murray cases because of fairness concerns, but no one's briefed that. And so the court doesn't address it in this order. And if, I guess my point being, it's sort of, everybody's sort of arguing about what people didn't say. And, the court could have said, wait a second, this whole time we've been thinking that these stipulations from 2013, 2014 in what becomes the Brooks cases continued to bind people to the Daubert litigation. And that's just that, right? And the court doesn't say that.
well, when Judge Josie Herring gets on the bench following this remand hearing in 2016, Judge Weisberg's
that I'm
order,
talking about.
2017. At that point, when Judge Weisberg entered that order, Judge Josie Herring also entered her first order. And then within a few months, sent an email to the plaintiff's cases, to the plaintiff's lawyers, who all represent the same parties, the plaintiffs in Murray, Brooks, and the Plon cases, which is a whole nother set of cases that are currently on appeal, and said, I've reviewed the entire record here, and I've determined that that the other cases have agreed to be bound, meaning the Brooks cases, have agreed to be bound by the general causation determination in the Murray cases. You Plon plaintiffs, there were certain 6 of them, have not entered into stay agreements. And if you don't agree to be bound, I see no reason why we should continue with the stays in those cases, and we should open up this general causation admissibility determination in those cases. And she said, please let me know if you agree to be bound. And the plaintiff's lawyers came back with specific emails that said, we agree to be bound by the general causation outcome in the Murray cases. At no point did any of the Brooks cases, any of the Brooks plaintiffs or the lawyers write to the court and say, hey, we disagree with your assertion or with your interpretation that the Brooks plaintiffs agreed to be bound. They're silent. Nothing happens. So I would say there wasn't any kicking the can down the road. Judge Josie Herring expressly addressed that issue at the outset of her tenure on these cases.
Part of your argument seems to rest on the fact that the same lawyers are representing all of these plaintiffs who ultimately get consolidated in 3 different groups. I think the plaintiffs cite cases saying, look, you can't just infer agreement because it's the same group of lawyers representing different groups. And what's your response to that?
Well, all those cases in which the plaintiffs rely on saying you can't rely on the lawyers being the same are sort of the virtual representation cases that didn't involve an agreement. And it's not the fact that the plaintiffs' lawyers are the same for all the plaintiffs is not the driving force, but it's certainly under the implied agreement test, under Taylor, under the restatement. That's actually a factor. That's one of the 5 or 6 factors that the court looks at to see if there's an implied agreement. So yes, you can't just infer an agreement to be a virtual representation, which was the issue under Taylor, by virtue of the fact that the lawyers are the same, but it certainly is a factor that supports a finding of an implied agreement to be bound. It also is important when you're looking at the totality of the circumstances in analyzing whether there was an express agreement, because, that's what Judge Irving found compelling. The judge who lived through this is that he was dealing with these lawyers. They were all representing the same plaintiffs.
I was wondering, sorry to interrupt, but I was just wondering, is there any case law that supports the proposition that when these plaintiffs' lawyers are talking to the court, that they're wearing multiple hats, right? So for example, at the post-remand hearing in 2016, when the court starts out by saying, well, I only issued the notice for the Murray plaintiffs, but, plaintiffs' lawyers, do you have any problem with that? Is there anybody who isn't here who should be here? And the plaintiffs' lawyers say, nope, we're good. It's sort of and then later on speak about the interests of their other clients in the Murray litigation. It seems like you could say, well, yeah, they were there in the Murray case, but they were also there representing their other clients. I mean, they were looking out for them. They had to have been. It seems like it might have been an ethical issue for them not to be. But is there any case law to support that?
I'm not aware of any case law that addresses that specific issue, but there certainly is case law that talks about the parties are, and I don't, it comes up in most directly for me in the Taylor case, particularly in the restatement, reliance on the restatement and the restatement factors that look at whether the parties are represented by the same counsel as whether there is an implied agreement. But certainly, at the very least, these plaintiffs' lawyers can't just put on blinders when they read orders that refer to other cases being, that they're in which they are the lawyers for the plaintiffs that say that they are bound by the Murray decision. It's not something from, and that's why you have to look at the totality of the circumstances, all the circumstances that exist in this case to find that there was an express and implied agreement.
You referred a moment ago to a response to Judge Josie Herring to the effect that plaintiffs agreed to be bound by the general causation outcome in the Murray cases. Do you have before you an appendix cite for that? I recall you mentioned this in your brief, so.
Yeah,
sure.
It's in our brief. Whether I have that specifically, I don't know. But it's in the record, and it is
split in the
yeah,
brief.
we have it in our brief, and it's also to the extent it's not, it's in the record. It's also quoted in Judge Irving's opinion granting summary judgment. He quoted not just the Judge Josie Herring's email, but also the response by the plaintiff's lawyers agreeing to be bound by the determination in Murray. And we agree with Judge Easterly's comments at the outset that, look, if you agree to be bound, then you're agreeing to be bound by the outcome. You're agreeing to be bound by everything. That incorporates the discovery, that incorporates all proceedings that relate to that outcome. Now, Judge Irving looked at it as both, the outcome and the discovery. And I think that's because there was express evidence in the record that the plaintiffs agreed expressly to be bound by the phase 1 discovery proceedings in Murray. And the Brooks plaintiffs agreed to be bound by the phase 1 discovery proceedings in Murray.
What is your response to the argument that even if they did agree to be bound over this span of time, that the motion to lift the stay in July 2021 was a attempt to withdraw that consent?
Well, certainly in July of 2021, there was the motion to lift the stay was an attempt to withdraw the consent, but it came way too late. You can't sit on your hands for 5 years after the change in the in the standard from FRI-Dias to Rule 702, and with all the subsequent events that were adverse to the plaintiffs, and then suddenly say we went out of the deal. I mean, that was the point of the case that this court decided, Charlton versus Mond, 987 A. 2nd 436 at 442. Quote, had the judge so seriously misconstrued party's motion, the time to object was then, not now, more than 4 years later. Here, we had a 2021 motion made 6 years after the court changed the standard. It's just way too late. There'd be no way that an agreement would be useless if the parties could just wait until all the adverse things happen to them and then decide, no, I'm out of the agreement now. I didn't like how it turned out. And that was the situation here. The plaintiffs made a bet. The parties made a bet but the plaintiffs made a bet on Murray, and they lost that bet. Now they want their money back, which in these cases is the equivalent of a general causation do-over. And Judge Irving properly rejected that effort below after looking at the totality of the circumstances.
Thank you, counsel.
Thank you.
I want to just start real quick by saying that the question of whether there was a full and fair opportunity to litigate this issue was in fact expressly raised below and ruled on by the trial court.
Why is it relevant outside of figuring out if there's an implicit agreement, right? Because it is a factor if we're doing collateral estoppel analysis, but I think everybody agrees collateral estoppel does not apply here.
I respectfully disagree with that, because collateral estoppel is the question of whether one party is bound by a determination in another case.
Have a final ruling in another case. This wasn't a final ruling. It's an interlocutory,
But
ruling
by-
about the admissibility of expert testimony.
By analogy, right? The issue is whether they're bound by a determination in another case and whether that is fair or violates their due process rights. So the question of whether
I hate to press you on this because we've been at this for quite a long time, but I really want to make sure I understand. You seem to be wanting to push us to use a framework that that they can't satisfy, that kind of everyone agrees they can't satisfy and is inapplicable. But really the central question is, was there or wasn't there an agreement? And you've got arguments as to why there wasn't an agreement. So I'm just trying to understand why you're trying to push us in the collateral estoppel, like black letter law, collateral estoppel does not apply, right? There was not a final decision. You didn't fully litigate. And I mean, you didn't have a full and fair opportunity to litigate before the final decision was, like, it just doesn't apply. Collateral estoppel is retrospective. And we're talking about before something was litigated, whether or not, and maybe sort of during, whether or not you acquiesced to the litigation of that issue. And maybe you did and maybe you didn't. And, we'll put our heads together and figure it out. But I just want to understand why you're trying to push us to collateral estoppel.
When you're taking away someone's right to a day in court, it has constitutional implications to process.
I felt not to cut
And
you
so-
off, but we were so over
Yeah, no,
time. We
but this
fully
is- there's
understand the
two-
black letter
Right.
proposition, the constitutional proposition that everyone has their right to the day in court. And we fully stand by the Taylor versus Sturgis, principle that no party should be bound by the litigation of, another party that they were not, a party to or privy, in privity with. That's fine.
Right, but
But
by the
Taylor
same
says there's a
token-
separate exception for agreements. And it just seems like that's where this case is. It is not in collateral estoppel land.
It's certainly one requirement, but if there wasn't a full and fair opportunity to litigate it, can you really bind them with the constitutional
So you're saying
implications?
you're saying your position is that we still have to run this through collateral estoppel? Like,
You have
even
to
if it were
decide whether there was.
absolutely clear that I said, I am, a 69th, a 70th plaintiff in this case. And I agree, going forward, eyes wide open, that I am bound by everything that happens in the Murray litigation vis-a-vis the admissibility of expert testimony under whatever standard, Frye, Dias, Daubert, some other standard that the Supreme Court comes up with in the future. I agree to all limitations on discovery up until that time. It is like clearly expressed. You would say, I still have to run this through a collateral estoppel analysis?
We'd still have to find that there was a full and fair opportunity to litigate the issue in Murray. Because otherwise, assume they agree to be bound and the judge is like, okay, great. Like, I'm determining that all your experts are inadmissible, but there's no hearing, no discovery, no nothing, right? Would it then be fair to say, okay, you're still bound by that agreement?
But we already, okay,
Well,
I think
and
we're going around in circle, but we did decide that last year in
in
Murray.
Murray under an abuse of discretion standard, where the court specifically found that reasonable minds could disagree about whether they had the full opportunity or whether they should have been able to amend their things, but they were giving discretion to the trial judge. Here we're doing it de novo. But let me pivot and talk about the agreement, because I think there was a question that we didn't get to in my argument, which is whether they also agreed to be bound by discovery. And the answer is no, right? The opposing counsel could not point you to a single statement that says we're bound by the discovery post remand. They pointed to a single statement at the beginning of the Murray hearings when 3 Brooks cases were filed. But as that hearing went on, Your Honor pointed out, Judge Easterly pointed out, that Judge Burgess made clear he was not going to allow general causation discovery. He was only going to allow discovery aimed at Frye Diaz. And plaintiff's counsel on the record made clear they would not have stipulated to a phase discovery under Frye if the only issue, and they were not, was going to be generally acceptance of the methodology, because we wouldn't be
They're saying
able
they
to
wouldn't
do-
have stipulated in Murray, but they did, and they were bound, right, in
But
Murray.
then they
And subsequently, they stipulate in all of these non-consolidated cases without, they never say in these stipulations, we agree to be bound by
Frye
the fourth
Diaz.
resolution of the Frye Dias hearing, but we reserve the right to do our general causation discovery, which you would think, it was a big deal at the 2012 hearing. If that was the sticking point, if that's where they wanted to part ways with the Murray plaintiffs, that they would have said something in these stipulations, and they don't. They
What's your
say,
response to the point I was discussing with your opponent, where, he made the point that plaintiffs responded to Judge Josie Herring by agreeing to be bound by the general causation outcome in the Murray cases. Is that wrong?
That's wrong. There is no agreement to be bound by, there is an agreement in DeRosa to be bound by the general causation finding. That's the broadest of the orders. But that order was made on behalf of DeRosa. The court then added language dicta to DeRosa that was not agreed to by any of the parties. But there's no obligation to respond to dicta. And that dicta was made at a
What do you
time where it
mean
was
there's no obligation to respond to dicta? You've got a court order that seems wrong to you that arguably could bind you. Don't you say something about it?
at the time of that order, right? If Fry Diaz remained the standard, the agreements would have stayed in place. So that order is ambiguous at best. And I do want to point the court, we didn't get to talk about it, the Zenith versus Hazeltine case. In that case, HRI, one of the defendants, stipulated that they were one and the same as their parent company. And so at the end of the case, Zenith moved to enforce the order against the parent company. That order, that stipulation, was signed by Dodds, who represented HRI, the subsidiary, and was also an officer of Hazeltine. He had signed that stipulation, and the Supreme Court held, nonetheless, it could not be enforced against the parent corporation, because when he was signing that order, he was signing on behalf of HRI. And this is consistent with the Supreme Court's constrained approach to binding someone to a case that is not their own. You have to narrowly construe the stipulations because you have constitutional issues, that right? And the same is true for DeRosa. That order was signed on behalf of DeRosa. And tellingly, when they responded to the Plon emails after remand about whether the Plon plaintiffs agreed to be bound by general admissibility, the email itself very clearly states, we are responding on behalf of the plaintiffs who are the subject of these emails. It does not say we are responding on behalf of all of the plaintiffs. There isn't a single statement in the record on
Right, but
remand
the
that they can
point-
point to.
The point is that the court has asked them and has said, and again, I think they've got to be wearing multiple hats when they get this email from the court that says the previous cases have been stayed pending the outcome of the general causation question and agreeing to be bound by the Murray cases. And if that's wrong,
In
you would think that the plaintiff's counsel would say, that's not exactly the posture of the other non-consolidated cases.
Zenith, Dodds, who was an officer of Hazeltine, was found not to be acting on behalf of
I
Hazeltine.
get it. I think
there
this
a
is
reason
very,
why counsel would have agreed on behalf of the Plon or DeRosa? Now I've lost who we're talking about, but why would have agreed on behalf of another set of plaintiffs to be bound by the general causation outcome, but wouldn't have agreed to be bound in the Brooks cases?
And it varies based on plaintiff. Each plaintiff has the choice that they make with their counsel about whether they're going to be bound. There are reasons to agree to be bound. There's reasons to agree not to be bound. And when we look at a particular plaintiff, we have to look at their particular agreement. And there is no agreement on behalf of the Brooks plaintiffs to be bound. And there's no agreement even if they agreed to be bound by the Dauber ruling, meaning that they would not be able to use the same experts. They didn't agree that all of their opinions had to be based on what was available in science in 2013, that they were going to get no general causation discovery, and they couldn't name new experts. And that is consistent. There was a stay after the remand. That was the December 2016 stay by Judge Weisberg, but there was no order, no agreement to be bound on remand, and there wasn't a determination that they would be bound on remand until the final order of the trial court on summary.
and yet they
Judgment.
took no steps to resuscitate these cases for years and years and years. So it just seems like they're operating as if there is an agreement.
Well, and Your Honor, I do want to, you had asked me, did plaintiffs argue, right, it wouldn't be fair to bind them? What did they say at that December hearing? I pulled that up while opposing counsel was arguing. And here is what counsel for the plaintiffs said. They argued it would be most efficient if you're allowed to amend and have all the science come in so that all of them could be bound. But if not, this is what was said. Well, but if you would have two tracks then, right? You would have a track of new cases going forward with all the new science and having full whatever experts we want. And then you would have this other track of cases that's been pending for a lot of years that are handcuffed back, and you can only use the experts that are available back 4 years ago. So
And
they,
then council says, and how is that efficient to have these two sets of cases like that?
right,
You
what
could put them together and say they all go forward with the benefit of all the new emerging science and all of the experts that have been available. That would be the most efficient. right?
That's the
So
agreement.
That is what they're not asking for the Brooks cases to be decoupled. They're sticking to their guns and saying, give us what we want in Murray.
No, Your
And
Honor.
they don't get what they want in Murray.
They're saying there's two options. If you allow the new science, we will agree to be bound. And if you don't, we will not agree to be
Well, that
bound.
would have been nice if they had actually put that in writing, but I don't, if you want to point me to where they did, but I don't read the transcript that way, and I don't see any briefing on that. And then Judge Weisberg says in that footnote, this wasn't briefed. No one asked me for this.
In that order, he says, okay, you can have the new science, right? Like, so there's no reason at that time to brief it because we've all agreed to the most efficient track, which is all the new science, and now we all agreed to be bound. And
Right, so you didn't object because at that point you had gotten what you wanted.
that point, we had all agreed. And then over the course of years, that order from Judge Weisberg gets eroded and eroded and eroded.
Right, so
So there's
you're
no-
saying you were happy to be bound while things were going your way. And you had reserved the right to unbind yourself once things started not going.
No, Your Honor. There was a particular condition to being bound, which is that we get to take into account new science. That's what's sufficient. And there is no agreement to be bound. There's an agreement for a stay. That is the agreement at the end of the 2016. That's what the judge orders. He says, I'm not going to order that they're bound. What I'm going to order is that it stayed. We're going to have briefing on what discovery goes on. So then there's this whole hoopla when we're for years deciding how much discovery, how much new science is going to come in. And at the end of that, when it is clear that there'll be no new experts and that new science is fully taken into account, the plaintiffs move to lift the stay.
What is the
And
point of being bound if you get to decide if you're bound after you know how the court is ruling, right?
not-
Like,
it's not a-
the whole point of being bound ex ante was that both parties took a risk and both parties didn't know how it was going to go, how much discovery was going to be authorized, what the scheduling order was going to be, whether Fry Dias was going to be overturned.
And that's
You
why there was
anticipate. And
no
now-
agreement to be bound.
You're saying they limited the risk. They took one, but only under this condition.
They agreed to a stay. They did not agree to be bound. And
I think we have your argument. Thank you very, very much. We
Thank you.
appreciate all your time, both counsel, and this case will be submitted. Thank you. The next case on our calendar is 24 CV 824 and 24 CV 1096. Estate of KD et al. Versus Children's National Medical Center et al. And KEIRA Moore et al. Versus Children's National Medical Center et al.
Morning, Your Honors.
Morning.
Morning. We'll give everyone a little
It's still morning.
minute to be settled. Yes, it is still morning. All right, I think we're ready now. Counsel, if you would introduce yourself for the record and let us know how much time you would like for rebuttal.
Of course, Your Honor, my name is Archie Rich, and I represent the appellants. In this matter, I would like to reserve 4 minutes for rebuttal.
Whenever you're ready.
Okay. All right, Your Honor, being conscientious of time, I'll jump right in. Your Honor, this case prevents 2 independent bases for reversal. First, the Superior Court granted summary judgment by doing what Rule 56 forbids, weighing evidence and making credibility determinations in the face of competing expert testimony. Second, the court enforced a purported settlement that never actually existed because, among other reasons, the parties never agreed to the same material terms, and because there was no client manifestation of settlement authority as required under controlling DC law. I'd like to begin with the settlement agreement. Your Honor, the trial court's order enforcing a settlement must be reversed. It rests on a foundational misapprehension of contract law and is a direct violation of this court's en banc holding in Makins and in other rulings of this court. Appellees asked this court to find a binding contract where both parties, just days before this appeal, explicitly told the trial court no such contract existed.
Where is that?
That is it references a representation in an email by co-counsel Francois Blaudot, where he indicated, I'm almost quoting, I believe, there is an agreement in principle. However, the parties have not signed the release.
Okay, so I thought you said there was a representation to the court that there had been no contract.
There was a representation of the court. And what I'm referencing is the joint motion to continue the deadline, to continue the deadline wherein both parties jointly represented to the court that parties were still discussing settlement and wanted more time to arrive at an agreement.
Okay, so let's back up to the August 30 email from Dr. Blaudot, is that right?
Yes.
Okay, so that email followed receipt of the release agreement by the defense counsel, right?
Your Honor, yes, that's the case.
Okay, and so in that email, Dr. Blaudot said we have an agreement in principle. And presumably that was based on the terms of this release agreement that had been provided. And so the suggestion that the release agreement changed the terms and that the withdrawal from the agreement or the decision not to agree was the result of that seems inconsistent with this email, which says we have an agreement in principle after having received and reviewed the release agreement.
Well, Your Honor, it is not inconsistent. First, there is an agreement in principle, while at the same time indicating to counsel that the settlement agreement has not been signed, and even referenced the fact that he was either unaware of whether or had confirmed that the release agreement had not even been viewed by the plaintiffs. And
I don't know if it says that. I mean, so you would agree, let's break that down. You would agree that contractual agreements can be don't have to be signed. Is that right?
Your Honor, I agree that in the general principle that contracts can be formed without signature. I disagree that the presidential cases in this case in which contracts were found without a signed agreement are analogous to the facts of this case. And first, let me address the statement, there is an agreement in principle. The phrase there is an agreement in principle by definition means there is not an actual agreement. And it requires a presumption to presume that the plaintiffs have first been provided with a copy of the release. That is not a fact that had been established at that point. And more than that, that counsel had an opportunity and completed that opportunity to carefully explain the impact of the release that was offered. It has to be noted also that at this time, there was not a pending, at best, the offer of the release agreement was a counteroffer. And I don't believe that there is credible dispute that, at least under the holdings of this court, that the initial, what is characterized by appellees as an offer, which was later accepted to create a binding contract, carries.
So why is it a counteroffer? Is it the reference to litigation costs? Or I guess the omission of a reference to attorney's fees?
It's not a counteroffer because the offer and purported acceptance was not mirrored in the offered agreement.
Right, and I'm asking how.
The offer required no costs. And first, I would submit that what was submitted to counsel was not an offer, but an agreement, to agree, which had not completely consummated an offer. But let's assume, arguendo, that that was the offer. The clear terms of that offer would have been that in exchange for the defendant's withdrawal of their motion for costs, and it's a fine point, but the court may see it as relevant here. The power of acceptance on the offer, if it was an offer, was that the defendants would withdraw the then pending motion for costs or motion for costs, and that counsel would not seek in the future sanctions. What was returned was a release agreement that did not contain one of the two terms. And so,
Which is what? The sanctions?
the sanctions. And in addition, defense counsel conditioned acceptance to that counteroffer with a signed release. And under the rules of this court, the offeror has the ability to define the terms of acceptance. And that is what the defendant did in this instance.
So read in context, the release statement that the defendants agreed to, one, and I'm inserting these numbers, I understand that, but one, withdraw their motion for costs, and two, waive their right to pursue litigation costs. How can two be read as anything but not different from one? And if it is different from one, what could it in context be meant to refer to from your client's perspective?
Well, in order to draw the conclusion that what was in the release satisfied the would-be offered condition, one would have to interpret boilerplate clauses in the release itself to mean those things, which is what the defendant tried to do here. And so defendant argues that embedded in the boilerplate language of the offered release, that it constituted an agreement to the second term. But that is not the mirroring that is required for mutual assent. And also significantly, defendant specifically conditioned acceptance on the client's signing of a release. And that did not occur. The agreement was never consummated. And in addition, that release contained additional terms that the court unilaterally decided was not material to their agreement.
So, counsel, the court made that ruling when? On October 30th, 2024. But the notice of appeal in this case was filed on September 9th, 2024.
That's correct.
Why did the court have jurisdiction to make that ruling?
Well, Your Honor, we're prepared to argue this matter on the merits, but you have it in our brief that this court did not have jurisdiction to rule. And the argument that appellee postulates to the court or offers to the court is that ruling still was still the province of the trial court.
Even though it affected our jurisdiction.
Well,
I mean,
This-
let's
this-
assume
the-
let's assume that that's true. And I just want to play this out and make sure I understand your argument. So say either we agree with you that there was no agreement to be bound by the appeal waiver, or we say the court didn't have jurisdiction to issue that order. Then we're looking at the summary judgment ruling. And we're going to hear your argument about that. But if we were to affirm, and we haven't heard your argument yet, so I don't know where we're going to go on summary judgment. If we affirmed, it would seem that the defendants could go back and say, we'd like attorney's fees, costs, and sanctions. Yes? And
Yes, Your Honor,
you're
yes, if this matter
opening
went
yourself
back,
up to that. You don't think they've been they would be stopped or in any way barred from doing that?
it's not my argument that they would be, Your Honor.
Okay.
These decisions are squarely before the court. We're prepared to argue this matter on the merits. You have our opinion that the jurisdiction was conferred to this court prior to that ruling. And it's unlike post-judgment rulings and post-appellate rulings regarding costs and fees. This isn't a simple matter of dividing fees. The ruling on that issue deprived this court of jurisdiction.
Should we turn to summary judgment then?
If you believe that, okay, you want me to do any of the judges have other questions on the merits of the agreement?
No, but let me just finish playing out the scenario that Judge Easterly was describing. So if we agreed that the trial court should not have reached the issue and decided the issue about the settlement agreement because the notice of appeal was effective to confer jurisdiction on this court, not the trial court, what should we do? So suppose let's just go with the scenario as Judge Easterly was describing it, and we'll hear argument on summary judgment, but let's say we agree that summary judgment was proper. And so we want to affirm the grant of summary judgment. We would just not rule on anything related to the settlement agreement. Is that correct? And then you'd be in the position of being back before the trial court where your opponent, I guess, could pursue its motion for costs and maybe bring a motion for sanctions.
Well, we don't believe that motion has merit.
Well, I understand that, but I'm just saying that that's where we'd be. That's where you'd be if we ruled in the way I described.
is.
Is that right?
It's our preference that the court rule favorably and consistent with its prior holdings that no agreement was formed. And we believe that
But if we think the trial court lacked jurisdiction to enter a ruling, essentially you'd be asking us to rule in the first instance on the enforceability of a settlement agreement or whether there was actually an agreement, and that's not something we typically do.
it's a fair point. I think that if the court elected to rule on the settlement agreement on the merits, whether or not there was an agreement on the merits, presumptively, under these circumstances, the court will have accepted jurisdiction.
I guess if, let's take it in reverse though. If we say the trial judge didn't have jurisdiction to enter an order after this case was up before us, enforcing the settlement agreement. And so that the enforcement order is null and void. And we move on to summary judgment. And hypothetically, we affirm summary judgment. Effectively, right? I mean, what's going to happen? It's, yes, we wouldn't be reviewing the order enforcing the settlement agreement, but it's defunct at that point because the bargain was for you not to appeal in return for them giving up fees and costs, right? But you got your appeal. So that has already happened. So it would seem that this would go back. We wouldn't review the trial court's order, but the situation on the ground would have changed significantly. And at that point, either the defendants could or could not pursue fees and costs. It wouldn't matter that we hadn't reached the merits of whether or not there was an agreement because the basis for the agreement will give up the appeal if you give up costs and fees. That's not available anymore to bargain for because you got your appeal, right?
I think that's procedurally correct, Your Honor.
Okay. So do you want to talk about summary judgment?
You move on to summary judgment, I feel a lot better at the court. If I had the court's ruling that the court did not have jurisdiction to find that there was an enforceable settlement, then I'd feel a little more comfortable with moving on to summary
Well, we
judgment.
can't give you that right now.
So
So can I reserve the
hypothetically-
right to return to the merits? See, whether or not I want to return to the merits depends.
so all I can say is
significantly
we are
on the
asking you to
court.
talk about summary judgment. So
Yes, sir.
about that.
Yes, Your Honor.
Thank you.
So thankfully, in summary judgment, the court doesn't need to resolve closed factual questions to decide this appeal. The error is structural. The trial court chose between competing interpretations of the same record evidence, particularly the testimony of Dr. Baker, plaintiff's expert. And in so doing, it stepped outside the limited role Rule 56 permits. As this court made clear in Warren v. Mid-Atlantic Health Group, summary judgment cannot stand where the trial court implicitly rejects an expert's testimony or credits one side's interpretation of disputed facts. That's exactly what happened here. Here, as in Warren, the dispositive problem is not that the appellant failed to come forward with evidence, but that the trial court treated contested issues as resolved.
Can you identify those contested issues that the court treated as resolved?
The ones that are most germane I would summarize as three at core. One, the emergency training adequacy. That is the adequacy of the training of the parents to be adequately prepared to deal with a predictable, foreseeable, in fact, inevitable life imperiling condition. Second, the safety of the discharge plan. Dr. Baker testified that the plan failed to ensure emergency response capability. The defense offers insurances, but that is a factual dispute. And also the interpretation of the medical record. There's an example. There are, as you know, the factual record in this case is robust. Dr. Baker viewed the apartment stay, to select an isolated example, but emblematic, as a warning sign. The defense calls it evidence of readiness. These aren't legal questions. They're jury questions. So instead of asking whether a reasonable jury could credit Dr. Baker, the trial court asked whether it should. And that is the error. And the appellees never actually confront this. Indeed, and it's a bit of a digression, we did a simple word search for appellee's brief for Rule 56. It appears once in their brief. We did a similar search for the Warren's opinion. Again, it appears once. And it appears both times to dismiss its application. The appellee does not even attempt to justify this ruling of summary judgment on the very law that defines how summary judgment must be tested. And for good reason. Because any test of the facts of this case make it clear that this court was outside the permissible boundaries of both Rule 56 and the Warren opinion. As the brief explains, the argument never engages Rule 56's requirement to view the evidence in the light most favorable to the non-moving party. They simply repeat why they believe they met the standard of care. But that's not the summary judgment standard. This is not a case where the plaintiff failed to produce expert testimony. We have expert testimony establishing the standard of care, deviation, and causation. The dispute is over what that testimony means. And under Warren, once you have competing expert interpretations, summary judgment is no longer available. Under Warren, a trial court cannot act as fact finder, weigh evidence, or implicitly reject expert medical testimony at the summary judgment stage. The Warren court overturned the trial court's counterinterpretation of the medical records that disagreed with plaintiff's expert opinion. Let me give a few examples here.
Counsel, you are out of time, so if you want to summarize, and then we will let you get back up on rebuttal.
Of course, it's indisputable as a matter of law that Rule 56 Warren defined the fundamental conditions that must premise an order of summary judgment. Accordingly, any argument before the court, the summary judgment cannot sidestep the clear requirements of Rule 56 and the Warren decision. I submit that it is telling, as I mentioned before, that the appellee mentions Rule 56 once and the Warren decision once, and both times in a non-explorative way by using the rule as a basis to test whether or not summary judgment was appropriate, but only raises it to dismiss it.
Thank you, counsel. We'll let you sit down and we'll hear from opposing counsel.
Thanks.
May it please the court, Alfred Belcourt for Children's Hospital and the two physician appellees. With respect to the settlement, we are invoking and relying principally upon two cases, two opinions of Judge Fisher for the court. The Dyer case, 983 Atlantic 2nd 349, and its predecessor, Eastbank. Those opinions provide the construct for the analysis. Here, as in Dyer, there is no dispute on what was said between the lawyers. It's all in writing in the emails and was made a part of the record, just as it was in Dyer. There was no dispute as to the authority of the counsel to speak.
So, counsel, let's just get to the heart of the matter, which is that the release terms that were sent back did change the language of what the offer seemed to be by replacing the phrase attorney's fees and sanctions with the phrase litigation costs. And I think, would you agree that litigation costs are not the same as attorney's fees and sanctions?
No, no. I would say that recoverable litigation costs may not be the same as attorney's fees, but as the authority in our brief states, many times costs of a lawsuit are taken to include attorney's fees. Does not mean they are typically recoverable, of course, under the American rule. But in this release, which I will read now in pertinent part, Your Honor has pinpointed one of the paragraphs, but above that, in the penultimate whereas conclusion, it states that claimants and defendants desire to settle all disputes and dispose of all claims. And then in the paragraph that Your Honor read, it says defendants agree to withdraw their motion for costs and waive their right to pursue litigation costs. The second clause would be completely redundant and therefore meaningless if it was only intended to apply to the motion for costs. Furthermore, whether or not there was ever a release signed would not affect the enforceability of the settlement agreement. Just as in Dyer, the parties agreed in an exchange of email and telephone response. It was made a part of the court record, but then they couldn't agree on a written document to memorialize that agreement. And the Court of Appeals, this court said, each party could reasonably be certain on how it was to perform. That's the mutuality of obligation requirement of Dyer, which is here. Quote, the enforceability of the agreement comes from the definitive character of the obligation to perform, not a precise description of the ways in which the obligation might be fulfilled. That's at 357 of the published opinion. So here, as the parties then communicated, are we going to dismiss our motion by a phone call, by a precipice, or by a motion to withdraw? It doesn't matter how it would be done. And it doesn't matter whether there would be a release even, because a dismissal with prejudice, of course, would have full res judicata effect. The point is, these words meant you would be willing to not seek an appeal if your client withdraws their motion for costs, and that you will not file any motion for sanctions seeking attorney's fees. This is critical now. Please take this to your client and advise of its position by 4 p.m. on Monday. At 1:50 p.m. on Monday, before 4 o'clock, defense counsel wrote, we now have consent from all three defendants. That was a contract. And not only was it effectuated then, it was confirmed 4 days later by plaintiff's counsel, who wrote,
So we're familiar with the record. What if we, even if we agree with you, what was the trial court's authority to enter its order on October 30th after the notice of appeal had been filed in this case?
because as we brief, there are two predicates. One could be called residual jurisdiction. I mean, for example,
I understand that there's a residual jurisdiction to decide costs after a case is on appeal, right? That doesn't touch on the right to appeal. But do any of your cases involve a situation like this one where there's a settlement agreement not to seek costs contingent on a waiver of the right to appeal? It seems like that in this instance, this order was not just ancillary to this appeal. It actually goes to our jurisdiction, which we don't generally allow the Superior Court to divest us of jurisdiction. In fact, we have a procedure where if a Superior Court judge wants to do something that would affect the life of the case that is before us on appeal, we tell them to file something under the Smith versus Pollen procedure to tell us, hey, you know, if you were to send this case back to me, I would dismiss it. I would vacate something. I would do something that would be dispositive to the life of the case. But I know I can't do it right now because the case is with you. And that's not what happened here. The court didn't say, I would grant this settlement agreement, you know, if I had jurisdiction, so that then, you know, you could bring that to us and then we could send it back for the settlement to be litigated. Instead, the court just purported to rule. And I'm just wondering why we think the court had the authority to do that, and, you know, why that would make sense to allow Superior Court judges to do that.
The closest case that I found is the Froelich case that I cited, which is a DC Circuit case. There was no actual notice of appeal filed, but there were parties were seeking leave to file one.
Seems like a big distinction, right? I mean, if
I
it's the
understand.
notice of
I
appeal, it's
understand.
kind of like the baton being handed off,
but-
right?
But
And we need to be pretty clear about that.
I think the distinction that's been made in the cases is that whether or not the ruling below after notice of appeal is addressing the merits. That's the old case, the Switzer case that was cited by appellants, early 1950s federal supplement. It was a Rule 60 motion trying to introduce new evidence on the merits. This settlement didn't go to the merits. Of course, the agreement to withdraw the appeal or not to appeal would take it out of this court. And there are other ways that it could have been done. It could have been done with a joint motion to this court.
Right, but it wasn't.
But it wasn't.
So,
All
I
right,
mean,
so where are we? Where are we going? Based upon some of the questions that you had for my friend, certainly this court could assume arguendo that there was no settlement and then affirm on summary judgment.
why would we even have to assume? Why wouldn't we just say the court's order that was issued after the notice of appeal was filed, the court was without authority to issue that order? And so we're disregarding that order. We don't think that the court's order after the notice of appeal has any effect on our jurisdiction to hear this appeal. So the one issue before us is the summary judgment issue. And we can either affirm or reverse on that issue. And if you want to talk about summary judgment,
I do.
yeah, we'd be
Certainly.
happy to hear.
But I also think, just as a final paragraph on the settlement, doing that does not fairly take into account the trial judge's effort to enforce what was an obvious meeting of the minds, confirmed by the plaintiff's counsel. And as Judge Ruiz wrote in her separate opinion in Makins, the parties and our system depends upon, reliance upon statements made of lawyers that they be true.
Counsel, sorry. Oh. I know you want to get to summary, we all want to get to summary judgment, but let me ask the flip question. If we were to agree with you that the trial court had jurisdiction and that there was an enforceable settlement agreement, what happens then? I mean, we have the other appeal before us.
No, that becomes moot.
Well, how? I'm procedurally, what do we do? What do you tell us to
Well,
do?
both the appeal on summary judgment and the appeal on the settlement agreement have been consolidated before your honors. It seems to me the logical first issue to be resolved is whether or not there was a settlement. If there is a settlement, then that means that in effect, there never was a need for this court to consider summary judgment. So the resolution would be dismissal of the appeal on the summary judgment motion.
Like we dismiss the appeal ourselves?
Yes.
Well, I'll have to think about that, but
Yes, that's it. That's what I think. But there was good grounds for summary judgment. The court did not discredit the sole expert for the plaintiff. It was not a weighing of our experts versus his experts. It is whether or not there was sufficient evidence under Hunt, which cites Liberty Lobby. Yes, I've seen the commercial many times. The Anderson case would be easier to say. Whether or not there was sufficient evidence to have a reasonable juror accept what Dr. Baker said, and therefore the plaintiffs earned the right to go to a jury. There was no evidential basis for Dr. Baker's opinion. He could have said what he said in the utmost good faith, but it was conclusion and not evidentially based. And I'll show you why we think that is true. He based his opinion, and this is at the appendix at 567, on a lack of documentation, on the mother's deposition, and on the event itself. But he conceded that he did not review the records of the child's stay at Children's Hospital. He said that's exactly correct at appendix 543. He did not read the deposition of the father at appendix 567. And the training was significant, both at Children's and at the second facility, the Hospital for Sick Children. There were at least 34 training sessions at Children's over the span of 13 weeks. Cited in our brief, it's Defendant's Exhibit 6 at summary judgment. 34 sessions, at least 26 additional sessions over 19 weeks at the Hospital for Sick Children.
Did he opine that those were insufficient?
Did he opine that? Yes. He said there should have been more of the same. He never specified what the so-called deficiency in emergency training was to be. In fact, they were trained for emergency situations. Here's an example. A few days before the child was discharged in June of 2018, there was an overnight stay. And during that overnight stay, there was oxygen deprivation, a lack of oxygen saturation. And the mother took emergency steps by doing what's called, you may know, bagging the patient by placing an inflatable resuscitation bag over the hole in the throat where the breathing is now occurring, and pushing it, compressing it to save the child's life. That was recorded in the medical records. This is Defendant's Exhibit 3 of the motion for summary judgment. 8649 is the number. The nurse said that's correct. The registered nurse explained this was proper technique to properly re-ventilate and ensure a patient is getting the correct oxygen Mother expressed understanding and agreed. That's a contemporaneous record that Dr. Baker never mentioned. When the incident occurred at the home, part of the emergency effort to save the child was to bag the child, just as she had done, just as the mother had done a couple of days before. The father performed CPR, just as he had been trained to do and testified about in testimony Dr. Baker never even read. There was also training in the suction, how to recognize the need to remove secretions from the tube.
I just want to make sure I understand the record. So the expert did not review the medical records from the hospital,
From Children's Hospital.
but is that separate and distinct from the records about the training?
Well, there was training in the records of his stay at Children's Hospital. So yes, he missed all that training. He didn't read about
So the
it.
training was documented in the medical
Yes,
records.
yes,
There's
oh, yeah.
separate record evidence of training outside of the medical records.
I'm talking about Children's Hospital medical records. There's also Hospital for Sick Children, HSC medical records.
Right,
And there's
yeah.
training in those medical records.
Okay,
Then there's the deposition testimony of the mother and the father,
okay.
We're
So he
talking-
reviews the deposition testimony of the mother,
but not the father.
but not the father.
And he did not review a big chunk of those medical
It's
records.
from Children's
Children's.
Medical,
That's correct.
but he does review the medical records from the other
Yes, he
facility.
did.
Okay, and those were closer in time to the discharge. Right?
Well, she
Wasn't that
stayed
the
at
facility, right? She moves from
Children's to,
yeah,
that's correct.
okay.
That's correct. And, but there were apartment stays, in other words, the overnight stays with the parents, with the child in the hospital. And during that stay, as I referred, I'm repeating now, there was the emergent need to resuscitate, not resuscitate, but to assure adequate oxygen. The statement in the records was the parents said, we are ready to treat the child at home. We are ready. Mom was emphatic about that in her deposition. The answer to that was Baker's speculation that I think the word ready may mean multiple things. This is at Appendix 557, 67. What the parents said may not express their true intent. We can't have an expert speculating on the intent. When a mother says we're ready, and she testifies in her deposition, I meant it when I said it. And she's been trained over 50, 60 times between Children's and the Hospital for Sick Children. There's no basis for the judge to say, I can't accept that. It's up to the plaintiff to point out evidence, in fact, where there was insufficient training, more than to say they should have done more of what they did. What they did was good, but they should have done more of it. He said emergencies, but he also said, Dr. Baker, that a simulation, in other words, simulation of an emergency could not be possible with these facilities and is not required by the standard of care. So all you can do is train to deal with the child and explain what the emergencies might be. And if they've encountered them, give them a grade on how they performed. And if they do well, all you could do is release, as they did, to 24-hour professional nursing care as supplemented by the parents who were adequately trained.
Counsel, you are out of time. If you have one last point you'd like to make, otherwise we'll let you sit down.
The final, yes, one last point, thank you. The final leg of Baker's faulty three-legged stool was that the event happened. And it's obvious in medical malpractice jurisprudence. One cannot say there's been a breach of the standard of care based upon the retrospective analysis of taking it from what happened. And that's what he did. That was his third prong.
Did your brief also suggest that the summary judgment record was deficient as to causation?
Yes, and that's what the trial court found. at Appendix 85, the court said plaintiff's argument that even more of the same type of training they had already received would have changed the outcome is wholly speculative. We had argued that in our reply, for example, at pages 9 and 10. Only speculation that more of the same training would have made a difference. It's only speculation. The trial court agreed with that. It's barren advocacy to say it wasn't preserved below. So yes, that would be another prong on which summary judgment could be granted. The trial judge cited, as we did, the Garvey decision, which is one of the lead opinions in this jurisdiction on causation, Garvey versus GW Hospital. And Dr. Baker himself said, we cannot foresee the future. This is at Appendix 534. So for these reasons and for all the other reasons spread upon our brief, we believe that the trial judge scoured the record and correctly held that there was a settlement, a meeting of the minds here, enforceable, and properly enforced it, and scoured the record and critiqued Dr. Baker, did not say he was lying, just said that he wasn't a basis for his opinion. And under the jurisprudence of summary judgment law in this jurisdiction, she made the correct decision there as well. So for either or both of those reasons, the judgment below should be affirmed.
Thank you, counsel. Mr. Rich?
Yes. Thank you, Your Honor. I will endeavor to be within my 4-minute time frame. First, I want to point out on summary judgment that, again, appellee has not made arguments related to the rules that confine judges in ordering summary judgment. And these are trial arguments. The rules of summary judgment have not yet been confronted. Appellee has not said once that there are no material facts in dispute. And for that reason, defendants
I
are
thought that's what he
entitled
was
to judgment
saying.
as a matter of law. Can you hear me?
Yes.
Okay.
I thought that's what he was saying by saying, look, the court found that there was, not sufficient evidence of causation, that it was totally speculative. And that is something that a court can say on summary judgment, right?
All right. On the causation issue, yes, Your Honor, court can say that. On the causation issue, first, as we've recited in our brief, that appellees are now trying to defend the judgment on causation grounds that they never argued below. They litigated summary judgment entirely on duty and standard of care. They cited no causation standard, developed no causation argument, and never argued that Dr. Baker's testimony was insufficient on causation. Now on appeal, being deficient on the requirements.
But the trial judge, am I mistaken that the trial judge said that the evidence was deficient on causation?
Well, the point, Your
I mean,
Honor,
if the trial judge says that and we're reviewing the trial judge's order, then it's before us, no?
well, we believe that permitting a shift when causation was not disputed in the lower court
I'm
briefs.
just looking for an answer to my question about what the trial judge said. Am I correct that the trial judge said that the evidence of causation was speculative?
Let me address that directly. I'll address that directly.
A
Appellees.
yes or no would be the most direct way of answering it.
Yes.
Thank you. Just in the interest of time.
Okay.
Your clock is
So,
counting down.
The court did do that, and appellees make much of the fact that Dr. Baker used the word speculate when asked if more training would have saved KD's life. The trial court agreed, ruling that arguing more training would have changed the outcome is wholly speculative. So why is the court wrong? Trial court is wrong because it cherry-picked the word speculate while ignoring the substantive clinical opinion Dr. Baker provided immediately alongside it. Under Rule 56, the court is required to view the testimony in the light most favorable to the appellants, the non-moving party, not to weaponize a semantic phrasing, cherry-picked phrasing in a deposition transcript to deprive, to replace the requirements of Rule 56. when you look at Dr. Baker's actual testimony, he draws a direct causal link between adequate emergency training and baby KD's survival. He explicitly testified, I think if the parents had been fully trained and the nurse not, Corey Dews could have survived. And so, Your Honor, again, Dr. Baker gave clear opinions in his published opinion, as well as in deposition testimony, that at a bare minimum created a material fact dispute and would require agreeing with the conclusions of one expert over the other.
Do
And-
you
and summary
agree
judgment
that
does
he
not
did
permit
not
this.
review all of the records of training?
Well, Your Honor, I would submit to you that the fact that he did not review those records are irrelevant to his conclusions for this reason. You know, appellees say that, you know, give a list of all the things that happened in training and then give a non-list, a speculative list of the things that happened during training much earlier at a facility. It's almost as if to say, Dr. Baker says, there are no quarters in that jar. And appellees think it's okay just to count the pennies. It's not the fact of training itself. It is his opinion that when baby KD was discharged to home, these doctors, the parents were not adequately prepared to do the things that were foreseeable under the circumstances. Baby KD had severe pulmonary dysplasia.
We're aware of her condition,
And you
so I'm going to
cannot
ask you
give-
to wrap it up.
Okay. So it's probably true that this was the first time a baby that sick, ventilator dependent, a 0 to 1 child had
Saying-
been discharged.
You're saying it's probably true? Do you have any evidence of that? Is that in the record?
Well, we asked that direct question numerous times in deposition, and the answer was avoided. We were.
Don't have, okay.
This is what I. Okay.
Final words, thank you.
Regarding the sufficiency of the record on the question of the sufficiency of the parents' training, the record is robust with testimony that was and some that was admittedly not reviewed by Dr. Baker. And Dr. Baker opined voluminously on the fact that it was his opinion that that training was inadequate and that it was indeed a substantial factor in causing the demise of this child. And for the court to conclude that that was not the case, the only way the court could get there is to skip past all that testimony. And certainly the court could not construe all material facts in favor of the plaintiff, as the court was required to do under the clear rules articulated in Rule 56 and the precedential case, the standards in Warren.
Thank you, counsel.
Thank you.
Appreciate your argument. Thank you. The case will be submitted. The third and final case today has 4 case numbers. They are 25 CO 115, 116, 398, and 399, all captioned as Gregory Bryce versus the United States.
Good afternoon, Your Honors. And May it please the
afternoon.
court. May it please the court, Adrian Madsen on behalf of Gregory Bryce, I'd like to reserve 3 minutes for rebuttal. In connection with his motion for a reduction of sentence under the IRA, the Incarceration Reduction Amendment Act, Mr. Bryce submitted and repeatedly drew the trial court's attention to a declaration from an expert in the Bureau of Prisons, former BOP warden Maureen Baird, the same expert at issue in Henney versus United States, in which this court held that the trial court abused its discretion when it failed to expressly consider Baird's expert testimony when denying Henney's request for IRA relief. Ms. Baird's unrebutted expert opinions bore heavily on at least factors 3 and 5 and included detailed information about the specific prisons in which Mr. Bryce had been incarcerated, including at the times that Mr. Bryce was incarcerated in those prisons and the frequency of violence in those prisons. While Ms. Baird's opinions included that Mr. Bryce's adjustment and actions since 2006 were not indicative of an individual who poses a danger or threat to the community, they were not by any means limited to that. Ms. Baird also offered other opinions relevant to whether Mr. Bryce had substantially complied with the rules of the institution, such as, quote, fights are common, as are assaults and attacks, at times with makeshift weapons. That's at paragraph 23.
So, Mr. Madsen, let's, as I said in the last case, cut to the heart of the matter.
Sure.
We all know that her report, I think is what the best term for it, was written before the 2023 infraction. And so at what point is the trial court, and we don't, I mean, admittedly, we don't know what the trial court thought because he didn't mention the report. But at what point can we assume that Ms. Baird's report was either no longer particularly relevant on this question, or that the failure to address it is harmless in light of the 2023 infraction, which really drove the bulk of the trial court's analysis in denying relief?
Sure. So I guess a few responses. One is at the October 11th hearing, I of course appreciate that the report, as we can refer to it that way, was submitted prior to the trial court's awareness of this disputed 2023 infraction. But we have counsel below saying at the October 11th hearing, it's not entirely clear what the basis for this is, but saying that Ms. Baird is aware of this infraction.
I mean, without the basis for that, I mean, I'm not saying we won't think about that at all, but let's put that aside for a moment.
Sure. I mean, I think that in the preface to your question, Your Honor, that you sort of answered your own question in a way, that is that we don't know at all what the trial court was thinking. But even if we were to assume for the sake of argument that based on the timing that would impact the weight that the trial court was giving to the opinions in the report, which again, it never did, it still, there were other parts of the report that would have borne on the trial court's analysis that it didn't address at all. So in other words, under the first prong of factor 3, where the trial court is evaluating whether there is substantial compliance, the trial court, for example, relies on this 2006 infraction, and Ms. Baird's report includes a number of opinions that are relevant to whether, when considering that infraction, Mr. Bryce had substantially complied, if that makes sense. That is, she says that this, including having been the warden, warden or acting warden of the prison, very close in time to that infraction, that essentially it was kill or be killed. She said, uses another word, eat or be eaten. I don't remember the phrase exactly in her report.
So I'm sorry to interrupt you, but I mean, I think there's an argument that the September 2023 infraction could cause someone to reconsider their view of the 2006 incident, perhaps, and his compliance with, rules and regulations in the facility generally. We don't have an updated report from her, right? Her report is May 2023. He files his motion for IRA relief in August. The incident is in September of 2023, and the hearing isn't until October of 2024, I believe.
Correct.
So there's lots of time for defense counsel to go back to Ms. Baird and say, okay, this happened, you know, it'd be really helpful if you could reiterate what you said, even in light of what happened in September 2023. And that we don't have that.
Agree, we don't have that. I guess I would point to a few things. One is, again, we do have, you know, for whatever it's worth, we have defense counsel's statement at the hearing that Ms. Baird is aware of this. It doesn't, I will say, it doesn't go challenged by the trial court. It doesn't go challenged by the government.
Evidence,
I-
yeah.
I agree. We also have the understanding, of course, that it is Mr. Bryce's burden. When we have the trial court, when it is asking, consistent with B2 of the IRA, saying when it has specific questions about those, it asks, right? That is, you know, says, you know, were these incidents referred for prosecution? Was there this contemporaneous evidence of self-defense? And the trial court does not say, you know, is there, well, wait, what about, you know, the fact of the timing of this report? What about that? Or we also have, and this was in a November 2024 supplement, which again, I acknowledge, of course, doesn't get us to an updated report. But we have a footnote where counsel essentially says, you know, that he may present an expert report. He doesn't regularly work under the CJA. He's not sure how to do it. And then there's just sort of no further discussion, you know, one way or the other about that. But I think it's possible, again, that a that a fact finder could give lesser weight, but we just don't know because the trial court, despite, you know, giving an oral ruling here, despite giving a written order, just never says anything about it. And so I agree that that is a possible explanation, but you know, we don't speculate. The trial court didn't give that reason here, just like it didn't give that reason in Henney. Even in this court's more recent decision in Davidson, where there was a report from a non-testifying expert, where the trial court had engaged actively with the report, that is, you know, saying things about it. That, you know, this court ultimately found that those there wasn't a basis to say those things, but the court had engaged with the report, and this court nonetheless, you know, reversed and remanded. And so the broader point is really that we just don't know because the trial court didn't say anything about it. So the trial court might say, if this court were to remand, you know, I give it less weight for these reasons, but that should happen in order for this court to be able to review in the first instance.
It is perfectly clear, though, don't you think, that the trial court was bothered by the 2023 incident? It said so from the bench, and it said that in its written ruling as well. So when you say we don't know what the court was thinking, we do know the court was thinking that.
Yes, we know. I don't disagree that it's clear that the court was thinking that, but the question for factor 3 is substantial compliance with the rules of the institution. So it's not just this one infraction, and we have this 18-year period, or roughly 17, 18-year period beforehand without. And Ms. Baird gives a number of opinions that are relevant to that, about describing that as being exemplary, remarkable, you know, all the adjectives that she is using to describe it. And we don't know. So it's the trial court doesn't say, well, I take Ms. Baird's opinions. Here is this later infraction that occurs, and therefore I discount her opinion for this reason, and I also find not substantial compliance for this reason. But again, her opinions bear on substantial compliance, independent of even assuming, as the trial court found here, the accuracy of this 2023 infraction.
Well, the 2023 infraction could be taken to bear as bearing on compliance with the rules of the institution, but it bears more generally, don't you think, on dangerousness, for example. I mean, the court.
Well, it has to be. I'm sorry to interrupt, Joanna. Go ahead.
The court didn't have to address it under that item in the list of factors to be addressed, did it?
Well, I mean, as under this court's, both under the statute, this court's decisions and Doe, Riley, it has to be considered within a statutory factor, right? There's not sort of and I understand there is factor 11, the catch-all. The trial court said it wasn't considering anything under factor 11 here, so we are limited to factors 1 through 10 in which the trial court could consider this. It talks about it in the context of the first prong of factor 3, and it talks about it in the context of factor 5 as well. But I guess to answer your question more directly, it would need to be specific within a statutory factor.
You're certainly right that nowhere in its ruling did the court mention Ms. Baird's name even or the report, but it does seem to me that there are places in the court's ruling where it relies on information. The court relied on information that came from Baird's report. I'm thinking, for example, of the reference to Mr. Brice separating himself from other DC inmates, which I think shows up in the briefing in the case before the trial court, but came from a statement to that effect from Ms. Baird. So I think it would not be very hard to see that the court relied on some things that were discussed in that report. Would you agree with that?
So I agree that that is discussed in the briefing, and I agree that it is also discussed in Ms. Baird's report.
And as far as I can tell, not discussed elsewhere. In other words, there's no other affidavit in the file, for example, in the record that says he's segregated himself from other DC inmates. The only place you can find support for that is in Ms. Baird's report.
I think it is also sort of asserted in the motion. I agree, not tethered to another affidavit, but that's the only distinction I would see there. But I think again, and this was discussed some in the reply brief. The fact that an expert, or excuse me, that a trial court may have considered some of the same facts that are discussed in an expert's report was, for the same reason in Henny, is not the same as considering the opinions in that report. That is, they may very well be considering some of the trial court may be considering some of the same information that the expert did, but we don't have the trial court's any reasoning here at all for departing ways with that expert, as this court said in Henny, and again, more different expert, but more recently in Davidson. And I'd just like to highlight that the 4 factors that this court further relied on in Henny to in deciding to remand for the trial court to directly address their testimony were: 1, the trial court viewing it as central to its decision. We have that here. 2, that Henny's stress upon this. We have the same here. We have Mr. Brice referring to this at least 6 times, Ms. Baird's opinions in the written motion. We have him addressing it in the reply. We have him discussing it in the hearing. We also have, just as in Henny, Mr. Brice emphasizing that the government had entirely failed to address Baird's expert opinion in its written opposition. Have the fact that the report was unrebutted, and again, the fourth factor where this court couldn't figure out the reasoning, that is, whether it generally credited Baird's testimony there in Henny and found that it was outweighed by these infractions, or if it instead discredited her testimony for some other reason. And so all sort of on all fours here.
Well, she said it was unrebutted, right?
Yes.
And I mean, I guess as a procedural matter, it was, the government didn't rebut it, but we probably don't have to go through this again, but it seems like it was effectively rebutted by the very fact of the 2023 incident, the existence of that incident.
So again, I think there are facts or opinions, excuse me, in her report that are bear on. I'll just say that the trial court, even though it was clearly concerned about the 2023 incident and the 2006 incident, as it said, never actually makes a finding about whether Mr. Brice has substantially complied or not. And at least from Mr. Brice's perspective in this appeal, if we might be in a different position if there was no expert report, and we might just say, well, the trial court didn't make a finding about this, but because we have this report that included opinions relevant to that, the first step is to remand for the trial court to expressly consider, as this court said in Henny, and to actually make a finding about whether there is substantial compliance, which is sort of an argument that is independent, which is raised in the briefing here, related but distinct, that even if we have this 2023 incident, that one incident in the 18 years prior, that is 3 years longer than is required for eligibility under the IRA, that a finding that is not substantial compliance, it was on the merits and abuse of discretion, even independent of Ms. Baird's report.
As you mentioned, the trial court was interested in whether or not the 2023 incident had been referred for prosecution. It caused me to wonder whether or not a prisoner has any recourse when there is a hearing officer finding such as there was about that incident. Do you happen to know whether there is? I mean, is that the end of the road when the hearing officer says, so I don't believe you lacked culpability in this? Is that it, or is there more?
I will say it's not on the record here. I'm happy to answer. I mean, there is an appeal process that I don't think there is, if my recollection is correct, I don't think there's record evidence here about.
I don't think there is either. I just
whether it happened, but there is, I know under the Bureau of Prisons regulations, yes, there is an appeal process in terms of the DHO disciplinary hearing officer finding. And I will say that while we're on that subject, the trial court doesn't actually make a finding of what the facts of this 2023 incident were fairly heavily disputed. We have these multiple affidavits, and it's clear that in some ways the trial court is weighing this against Mr. Bryce, but doesn't actually make a finding about what its finding happened. I mean, there's not a claim of error specific to that raised here, but the trial court says essentially, we've got this evidence, and at the end says, well, the injuries are not consistent with what Mr. Bryce alleges here, but doesn't say, and therefore what I am finding happened, was what was in the report, right? Doesn't say, this is what I'm actually finding happened as a result of that, and here's why I am weighing that against Mr. Bryce. I see that my time has quickly gone, and I will sit down.
Thank you, Mr. Madsen. We'll have you back up in a little while. Mr. Darby.
It please the court, Alan Darby for the United States. This court should affirm the denial of Gregory Bryce's IRA motion because Bryce failed to establish non-dangerousness below, and the trial court's determination was well within its discretion. I will say at the outset that because my colleague on the other side didn't address factor 10, I would rest large on my brief unless the court has questions, which I would be happy to answer. I would also acknowledge at the outset that we agree the trial court did not explicitly cite to Baird's declaration. However, the trial court's conclusion did not diverge from Baird's assessment of the evidence as it existed at the time of her declaration. The trial court acknowledged in its order Bryce's 18-year spotless record before the 2023 incident and said, quote, Bryce was well on his way to a level of rehabilitation sufficient to warrant his re-entry into society. Nevertheless, Bryce, after Baird's declaration was issued and after the filing of his IRA motion, assaulted with serious injury his cellmate. Baird's declaration did not and could not have considered this dispositive intervening fact. And I would like to note, because of our 28K letter, there was a proffer by defense counsel below. However, it is bare bones. It is very ambiguous. The first sort of representation about she's aware of the allegations. I mean, it wasn't an allegation at that point. There was a BOP finding that he committed this assault with serious injury. The proffer also noted that Ms. Baird allegedly did not believe Bryce to be, quote, of the character to have committed this assault. I really think that has no moment. because the trial court credited the DHO report. And it is ambiguous exactly what counsel was trying to mean by saying is ready to return home. And so,
Counsel, just taking you back to your point, what I thought you were saying was the court did credit Ms. Baird's opinion as far as it went. That, you know, her opinion as of May 2023 was that Mr. Brice had meaningfully complied with rules and regulations and, you know, was rehabilitated and should be released.
that's correct, Your Honor.
Right? But so I'm wondering, are you then telling us we should slot this under Henny, the fourth factor, where Henny said in that case that it wasn't obvious to us whether the trial court generally credited Baird's testimony and simply found that it was outweighed by the raw facts of the disciplinary infractions in that case. And I'm wondering, are you arguing that it is obvious that the court generally credited Baird, but that her opinion testimony was outweighed by the facts of the September 2023 infraction? Is that what you're saying?
Your Honor, the government's position is that it's implicit, but I do think this court can conduct a Henny analysis. I do think it's instructive, those four factors. And I will say also at the outset, the trial court was aware of Henny. Both parties at the motion hearing raised Henny. And if you look at the four factors.
I'm not sure which way that cuts, because given that everyone was aware of Henny, it seems it's disappointing that nothing was said about Ms. Baird's report.
That very well may be the case. It's not a perfect order. Nevertheless, the factors do not weigh in favor of vacatur and remand here. Ms. Baird did not testify at either motion hearing in October or December. There was no ability to cross-examine her opinion or her declaration. It was inconsistent and contradicted by the facts before the court at the time of its ruling, which is something that Henny explicitly stated and whether or not it was rebutted. So though I believe Judge Schenker was making this point, it was sort of implicitly rebutted by the changing dispositive facts. And this court has, quote, sufficient detail to permit appellate review as to why the court implicitly rejected Baird's conclusion at the end in February and then also in its written order in April. And that is the serious infraction, the 100 level infraction in 2023, the assault with serious injury on a cellmate. And my colleague on the other side also cites to Davidson. I would represent to this court, we do not believe Davidson to be on point there. The expert opinion was not inconsistent and was not contradicted by intervening dispositive facts. There it dealt with the trial court. This court vacated and remanded because the trial court thought that Mohammed needed additional sex offender treatment, did not explain why the trial court thought he needed more sex offender treatment, and then simultaneously rejected Mohammed's expert witness who said that they did not believe sex offender treatment was required. And so here the court can hang its hat on the fact that the trial court's determination was based on Brice's violent 100 level infraction that was incurred during the pendency of his IRA motion. And I do think the court picked up on this earlier, is that the court did give extensive weight to 2023, but that was coupled and that shed new light on the 2006 infraction. The court specifically stated, and this is at the February 3rd, 25 ruling transcript, pages 14 to 15, quote, ultimately in arriving at my decision to deny Mr. Brice's motion, I could not overlook the recent incident here, as well as that coupled with the 2006 incident, being both in his 30s and his 40s respectively.
See, that it seems like that cuts against you too, because Ms. Baird's report did address the 2006 incident. And so to the extent the court might have, if it had considered Ms. Baird's declaration, given less weight as a result to the 2006 incident, then how do we know it would have come to the same conclusion overall on dangerousness?
Your Honor, I would point directly to the language of the order, where there the trial court said, absent this 2023 infraction, this assault with serious injury, that Bryce was well on his way to a level of rehabilitation to warrant reentry into society. And then he commits this another violent infraction that creates, and I know my colleague on the other side has issue with this term, but pattern of violent conduct. He committed a killing in 2006, and then he was in Ad Max for 12 odd years.
You seem to be saying both things, that 2006 was important and that 2006 wasn't important.
Well, it's important in the sense that absent this 2023 infraction, it seems like the trial court agreed with Baird's assessment that he would be eligible for resentencing. But then
Sorry to interrupt, but that takes us back to my question of, are you arguing that the court agreed with Baird up to a point, but then the 2023 infraction was a game changer? Or are you arguing that the 2023 infraction was powerful, not only in and of itself, but also caused the court to discredit Baird's assessment of the 2006 infraction? And if that's the case, it just seems like we're squarely in the zone of Henney, where the court said, look, it's not obvious to us whether the court generally credited Baird's testimony, simply found that it was outweighed by the raw facts of the disciplinary infractions, or if instead the court discredited her testimony for some reason. And I feel like, well, now I don't know which the government thinks. And if the government doesn't know, then maybe we need the court to tell us.
I don't think it's a dichotomy, Your Honor, because the specific language in Baird's opinion was that this 2006 incident was a catalyst for a change in his life. And so if he's committing this 2023 infraction, that sheds new light on what actually this 2006 infraction was. And so, and I do think that can be squared with the fact that, I agree with Baird's declaration as the declaration existed at the time before the 2023 infraction. But once the 2023 infraction happened, it was true then, it's not true now. And I think that can be squared with viewing those together. I would also like to touch on the factor 3. Appellant makes an argument that there was no specific finding of substantial compliance. The trial court logically could not have held, and this goes hand in hand with the DHO report, the lack of finding there. The trial court could not have held the 2023 infraction for assault with serious injury against Bryce had it not credited the DHO report and found that he was not in substantial compliance with the rules of the institutions he was in. It cannot be the case that the trial court believed he was in substantial compliance, but found he was, he committed this 2023 infraction, or did not credit the DHO report and credited McNeil's and Bryce's recounting of the events, but then held the 2023 infraction against him. That's not consistent.
Your brief suggests that the reference to the sparse release plan might have been a reference to something that the victim's family said, but I find that one difficult to follow. Do you really think that? What would you point to in their statements that supports that?
So I do believe that is the most logical reading of the entire record.
I'd suggest the most logical reading is a typo they didn't take out, that they were cutting and pasting. Doesn't that make more sense?
That very well could be the case, and then that obviously would be harmless error because there was no indication that the trial court would have ruled the other way. But if you look at the entire record, the appellant does not take qualm with the trial court's findings on his release plan, or saying that the trial court clearly erred in its findings. At the motion hearing, the trial judge credited Mr. Moon's testimony, who was Mr. Bryce's witness, said he had a, quote, very comprehensive and well-developed plan to reenter society. And then in the page before, in the order before the sparse release plan language, the trial court said, quote, he has support from his family and friends, and he has a release plan to facilitate his successful reentry into society. So I think the best way to square the sparse release plan language is the victim's family was skeptical. And I don't think that the victim's family had to know the exact release plan to say that they were skeptical, just that any release plan Bryce could put forward, he's going to come into our community, he's going to brag about killing my family member. And that would be consistent. But again, it's of no moment, because even if it was error, if it was plugged in, as Your Honor suggested, the trial court ultimately denied the motion because of his violent disciplinary history. Sort of pivoting back to factor 3, in regards to whether or not the trial court, and this was just a very brief question from the court, whether or not the trial court should be even sort of conducting this analysis on the infraction. I don't think they should, obviously, or clearly an appellant or a movement can make a mitigation argument as to 2006 infraction or 2023, but to actively question the validity of a BOP finding, that presents two clear problems, one a legal and one a practical. The first one, it's a claims processing issue. You have to administratively exhaust your remedies if you want to challenge this BOP finding or sanction. And then after that, depending on your exact claim, you could file a habeas petition in federal court or potentially a Bivens claim in federal court. It would not be the case that you could just collaterally attack it in an IRA motion in DC Superior Court. That is not proper. Second, the practical consideration is that if movements under IRA are now able to collaterally attack their BOP sanctions or the infractions, the upshot of that will be there will be a slew of affidavits being filed in these motions, and then we will have many trials on whether or not Joe Smith actually possessed a dangerous weapon back in 2015. And that's problematic and not workable, because factor 3 has become increasingly dispositive in current dangerousness, because IRA deals with personal circumstances. And so I don't think that's something a DC Superior Court judge should have to do. And if there are no other questions from the court, we would respectfully ask this court to affirm. Thank you.
Thank you, Mr. Darby.
Just to pick up where the government left off, I believe it's this court's decision in Riley, which wasn't briefed here, but in terms of the government saying you have to go through, this exhausted administrative remedies, this court in IRA decisions has looked at the facts, the underlying facts of an offense, for example, right, which may have been litigated through a trial or a plea or otherwise. That is, so to say that someone can't offer evidence that is relevant to a statutory factor. We're not talking, bringing a lawsuit here, right? We're talking about a trial court that is obligated to consider these statutory factors. So I don't follow that argument. The government mentioned several times saying, this could not have been logically consistent with this. Well, trial courts make mistakes. That's why this court is here. We don't know the trial court's reasoning here. And instead of, having my friend on the other side say, I think, right, we should hear from the trial court in the first place what it thought about these opinions in order for this court to be able to review. I think we are squarely, and I'm repeating the same error, but we are squarely in Henny land here. That is to your point, Judge Shanker, which is what I was trying to convey, and I think Your Honor rephrased it more artfully. The trial court did consider this 2006 infraction to be important, and Ms. Baird did give opinions that were relevant to that, and the trial court did not address them in evaluating it, whether it was under factor 3 or under factor 5, when considering that sort of lays out the arguments of the parties, but doesn't engage with Ms. Baird's opinions. The government also mentioned Ms. Baird not testifying. I'll just note that one, of course, we don't have the trial court saying that was a reason for giving any lesser weight, but two, the government didn't say anything about Ms. Baird's opinion in its opposition. Mr. Bryce highlighted that again in the reply. The government didn't say, oh, we'd like to be able to cross-examine her, right? The government didn't engage with her opinion at all in its written opposition, just didn't, ignored it altogether, as in Henny. And just briefly on the factor 10, I'll largely rest in the brief, but just want to say that, even assuming the accuracy of this 2023 disciplinary infraction, the trial court is considering in factor 10, which calls for whether the personal circumstances show an aging out of crime. It is looking back at this 2006 infraction, and what that factor is calling for consideration of is not whether personal circumstances showed an aging out of crime 18 years before its ruling, and that was error. And so for all the reasons already discussed, we'd ask for this court remand, leave it to the court's discretion about whether to, I would think that given the period of time that's passed, to open the record as to additional evidence in as Your Honor indicated, based on the timeline, something like 18 months since the hearing in this case. And unless there are further questions, that would be my request.
Thank you, Mr. Manson. Thank you again, Mr. Darby. Case will be submitted and we're done.
All right.